Really normally. Oh, okay.
Yeah.
Yeah. Oh, yes, sir.
Everything today.
All rise. County Circuit Court is now, Honorable Judge David Williams presiding.
Please bow your head for a moment of silence, please. Very much. You said I did last time. You know how that goes. Okay, Commonwealth, Kentucky versus Sammy Holland. For sentencing. This is 23 CR 0076, Commonwealth, Kentucky versus Sammy Holland. Are you Sammy Holland?
Were you born in 1985?
Yes, sir.
Last four digits, social security number 8437.
Yes, sir.
If you had an opportunity to go through 3 cents investigation report done with probation parole,
Yes, sir.
is it substantially correct?
Yes, sir.
Counselor, is there any reason this gentleman should not be sentenced today?
No, Your Honor.
On a plea of guilty possession of controlled substance first degree, the defendant shall receive a sentence of 3 years, probated for 5 years. Probation is to be supervised. On a plea of guilty to operating a motor vehicle under the influence, he shall pay a fine of $200 plus court costs. Upon a plea of guilty to failure to pay insurance, he shall pay a fine of $100. What are the total court costs? $950. Now, you realized when you enter this plea, sir?
Yeah.
When you enter this plea that this motor vehicle charge was enhanceable. You get another one. You understood that. Is that correct?
Yes, sir.
Okay, and that's the same thing of your felony plea. Is that correct? 900 what? Is he to get out today? Is Commonwealth here? Yeah, is he to get out today? Is that, you understand?
I
Just
don't
be
have,
probated, is that what you
Yes, Your
understand?
Honor.
yeah, we don't have.
Okay, what kind of payment schedule can you make? Can you pay $60 a month? You owe $900.
Yeah, I can do that.
Okay, I want you to pay your first payment 30 days from today, and 30 days, every 30 days after that, it's paid in full. That's a condition. You can get revoked for that too. Yes. Okay, thank you very much.
Yeah.
Let me just, I want to send that on down there. Check. Let me get another page. Take that downstairs. Bo's yours. Gonna pick that up front. Okay, thank you. Commonwealth versus Lance Humphrey. Commonwealth versus Lance Humphrey. You made arrangements to see probation and parole, I guess. Is that correct?
Yes.
When do you want him up there?
He lives in Richmond, Your Honor, so I have to transfer him. Once he gets released, he'll go to my office. I can collect his information. I can call him and schedule that.
You need to go over there immediately to probation and parole officer. You don't want to like. Commonwealth versus Lance Humphrey, 23 CR 0057. Are you Lance Humphrey?
Yes, sir.
Were you born in 1996?
Yes, sir.
Last four digits, social security number 5319.
Yes,
You're
sir.
here today for sentencing. Have you had an opportunity to look at the pre-sentence investigation report done with probation and parole?
Yes, sir.
Is it substantially
Yes, sir.
correct? Is there any reason that this gentleman should not be sentenced today?
No, Your Honor.
Plead guilty of tampering with prisoner minor device and escape second, he shall receive a sentence of 5 years on each to run consecutively for a total of 10 years, probated for 5 years. Sentence to run concurrently with 21 CR 0018 Cumberland Circuit Court. Offense shall receive credit for time served. And it said he was to be released for rehabilitation. What's the story on that?
Your Honor, that is correct. There is a order, a bed letter that is set for in the morning, and ARC will be coming to pick up Mr. Humphreys at the Adair County Detention Center in the morning.
Okay, and it's part of the order, if he leaves this facility without being properly discharged or against advice, he shall immediately report to probation and parole be taken into custody. You understand that, sir?
Yes, sir.
On completion of rehab, the remainder of the 10 years shall be probated for 5 years. What's the court cost this case?
215.
How much?
Total.
215?
Yes, sir.
Okay, 215. I'll let you start paying that 30 days after you get out
All right.
of rehab. You pay that for $60 a month. Okay?
Thank you,
Yes, sir.
Judge.
Thank you. John Richardson. Commonwealth versus John Richardson.
Your Honor, with I'm speaking for Mr. Roby. With regards to Mr. Richardson, Mr. Roby is en route. He's actually representing Mr. Richardson due to a conflict. So we can recall that.
Okay. Maria Riviera. What's the story on Maria Riviera?
That's an erosion. They say it's a transfer.
There was one.
There was.
Y'all contact the Monroe County Jailer to see if he's in or out.
Yeah.
Do you have his number? Jason Sherrill. Did Miss Riviera, did she need an interpreter?
Yes, there was something on the phone.
Okay. Let me see if I can get our net here. Yeah, let's go call it. Commonwealth versus Jason Sherrill, 21 CR 0041. You're here for sentencing. Were you born in 1976?
Yes, sir.
Last four digits of your social security number 8694.
Yes, sir.
Okay. Have you had an opportunity to look at the precinct's investigation report done by probation and parole?
Yes, sir.
Is it substantially correct?
Judge, it is, I think I don't have it in front of me, but in the PSI, there is an error on the date of birth. It doesn't reflect correct. I just wanted to note that.
Well, let's see if we can find that. It's 8/27/1979.
That is not
What
correct.
is the correct date of birth?
76.
1976. You just cost yourself 3 years.
And, and the date, I know, the date says 27th, it's the 29th.
8/29/1976.
Yes, sir.
Take note of that. Okay. On the plea of guilty, the column to possession of controlled substance, first degree, the defendant shall receive a sentence of 3 years to serve. All drug paraphernalia, contraband disposed of within the court's law. The court costs how much?
$685.
$685. Why is his court cost so much?
He had paid that portion.
He had what?
$500.
Okay. 601,
$685.
685. You need some time to pay that.
Yes, sir.
Okay, when you get out of jail, 30 days after that, you'll owe $60. And you owe $60 a month. Every month you pay that off in full, okay?
I pay that here.
Yes. You can mail it in, you don't have to come here. Okay.
They don't have him, I didn't get order on me. I just got the jail.
Oh, this is I thought we called the transportation office. This is the transportation office.
No, it's a Monroe County, they say we can transport.
I know, he called the jail and asked for Danny Arnett. He said,
Oh, okay. Let me call. It's a jailer over there.
sorry.
Hand me this number over here. Clay, do y'all have Danny Arnett's number?
One of us will do.
Okay. He's supposed to have Miss Riviera on the way over here. Could y'all check on that?
It said how much, $60,
I did, I just told you. Okay, that's it on that.
Thank you, Your Honor.
Jacob Smith. Caldwell versus Jacob Smith, 23 CR 0032. Are you Jacob Smith, sir? You were born in 1987. Last four digits, social security number 4054. You're here today for sentencing. You had an opportunity to look at the pre-sentence investigation report done with probation and parole. Is it substantially correct? Counselor, is there any reason this gentleman should not be sentenced today?
No, Your Honor.
On plea of guilty, possession of controlled substance, first degree defendant shall receive a sentence of 3 years to serve. Sentence, however, shall run concurrently with the Casey County case 22 CR 004. Court costs
$215.
$215. $215. You can start paying it $30 a month, 30 days after you get out.
$427. 6250.
Oh, Mr. Arnett. This is Judge Williams. Did you get a transportation order on Maria Riviera to bring her to Cumberland County today? Okay, I just want to make sure you're on the way. Okay, thank you. Bye. He's on the way in with her. William Spears. Commonwealth versus William Spears, 23 CR 0066, 3 zeros and 2 6s. Are you William Spears?
Yes, sir.
You born in 1974?
Yes, sir.
Last four digits, social security number 1612.
Yes, sir.
You're here today for sentencing. Have you had an opportunity to look at pre-sentence with
Yes.
for
Yes, sir.
PSI? Is it substantially correct?
Yes, sir.
Counselor, is there any reason this gentleman should not be sentenced today?
No, Your Honor.
On plea of guilty possession of controlled substance, first degree, defendant shall receive a sentence of 3 years. The sentence shall run consecutively to Cumberland Circuit Court, 22 CR 0037, a 3-year sentence for a total of 6 years. Serve 90 days in lieu of revocation, probated for 5 years, probation to be certified. Does he get it? Does he have his 90 days in yet?
Yes, Your Honor.
What's the court cost?
Take
Court costs $215. Start paying that 30 days from the day of your release at $30 a month. Okay.
And Judge, just be sure that will be in process today. Yes, thank you, Your Honor.
Probation parole's over there. Where do you want him to come?
One more is fine, Your Honor. 8 a.m. You do that?
Thank you, Your Honor.
Okay, we'll start with out of custody docket, Jason Bowers. Cumberland versus Jason Bowers. Cumberland versus Jason Bowers, 22 CR 0082. Are you Jason Bowers?
Yes, sir.
Your birth is 1984.
Yes, sir.
Last four digits, social security number 7956.
Yes, sir.
Here today on the pretrial diversion revocation. What was the comment that you say?
Your Honor, we won't have a hearing as far as I know.
Okay, get up behind the podium here so we can, there's a podium right there. What are the podium right there?
Okay, sorry.
What are the allegations that you have against this gentleman?
Have to, put the Garner on to give that, Your Honor. She can take it.
Mr. Garner, what are you gonna testify to?
Your Honor, he had a misdemeanor arrest for operating motor vehicle under the influence of alcohol and admission of guilt to the use of alcohol.
Are you gonna stipulate?
Judge, this is my first time actually meeting Mr. Bowers. I would have to consult with him before I can stipulate, even with the proffer on the record.
Well, we'll just take testimony then. That way you'll hear what the deal is. I'll make a decision. Take a stand here. You raise your right hand, you swear to testimony about to give us the truth, the whole truth, nothing but the truth.
Yes, Your Honor.
Go ahead.
You state your name, please,
It's Officer Jeremy Garner, probation and parole,
and how long your health disposition with Commonwealth of Kentucky.
5 years.
Are you in, one of the probation officers that are handling cases that's involved here, Mr. Jason Bowers?
I am.
And you supervise his probation,
I do.
and you have his records and you're familiar with it.
Yes, sir.
Could you please tell us about it, please?
All right, I was notified on 11/16, I'm sorry, on 11/1 that Mr. Bowers was arrested for the following charges on a Cumberland District Court case 23 Tango 788. He was charged with careless driving, failure to wear a seatbelt, operating motor vehicle under the influence, and possession of open alcohol beverage container in a motor vehicle. He's also got a violation for the use of alcohol. Mr. Bowers reported as directed, admitted to, signed an admission of guilt form to the use of alcohol on or about 11/1/23. Mr. Bowers admitted to consuming 4 16-ounce beers, and he was referred to the social service clinician for his alcohol use. And he signed an admission of guilt form to the use of alcohol, and I have a copy of the citation where he was arrested.
Pass him, Your Honor.
Yes, Your Honor. So, officer, and I don't have your report in front of me, so we're talking about one violation,
There's 2 violations, one for the use of alcohol and one for the misdemeanor arrest.
but relating to the same event.
Yes.
And you said that Mr. Bowers was referred to the social service.
He was.
What was the recommendation?
Outpatient treatment. He was screened by the social service clinician and evaluated at a level of care that requires Mr. Bowers to enter complete outpatient treatment. And also increased his level of supervision from low to moderate.
So not inpatient.
Not inpatient, outpatient.
Not throwing this young man in jail or prison, right?
No, I did not take him to jail, no.
And he was open and forthcoming about his admission to 4 drinks.
He was.
And that DUI charge, he's not being convicted of that yet.
As far as I'm aware, no.
That's all I have, Your Honor.
Your Honor, I don't have anything else.
Judge, we've heard one alleged violation relating to an alleged driving under the influence, but Mr. Bowers here stands before the court innocent and proven guilty of that crime. Judge, I'll note in.
He was out drinking and driving by his own admission. So I will hold the decision in abeyance till I see what happens on the DUI case. I'll have order.
Yes, Your Honor.
Thank you.
You're not to be driving a vehicle between the time I decide this to you. You understand what I'm saying? It's
Yes, sir.
condition of his bond. It's the bond. Thomas Bradshaw. Commonwealth versus Thomas Bradshaw, 23 CR 0085 yard. Thomas Bradshaw, born in 1964. Last four digits, social security number 7621.
Yes.
We have a pre-trial conference. What do you have? What's the Commonwealth have?
Now we have an agreed order.
No, actually, Judge, we don't, Judge. We need to set trial.
Okay.
What is the charge?
There's traffic offenses, Judge, but the felony charge is possession.
Commonwealth have all its information ready. Are you ready for trial?
Your Honor,
You have a lab people you have to schedule or anything, or what?
Yes.
we have that.
Thing to work. Got the lab reports and everything back?
We do, Your Honor.
We have anything on the 30th, like 2 weeks from today.
This, this is actually the one lab person that we need to do it's that same person.
She's checking.
Y'all know whether you got your lab person or not?
She's
Your Honor, checking on it right now.
Okay. Okay, we'll come back to this case. You just have a seat right over here. And that way, as soon as we. Angela Branham. Sentencing on Angela Branham. Howell versus Angela Branham. 23 CR 0052. Are you Angela Branham?
I am.
Born in 1973.
Yes.
Last four digits, social security number 1859.
Yes, sir.
You here for sentencing. Have you had the opportunity to look at the pre-sentence investigation for under probation parole?
Yes.
Is it substantially correct?
Yes.
Is there any reason counsel of this lady should not be sentenced today?
No, Your Honor.
On plea of guilty possession of controlled substance meth, the defendant shall receive a sentence of 3 years. On plea guilty to tampering with physical evidence, the defendant shall receive a sentence of 4 years. On plea guilty to operate a motor vehicle under the influence, 7 days in jail, $200 fine. The guilty failure to maintain insurance, pay $500. Three to 4 years shall run concurrently for a total of 4 years. probated for 5 years, supervised, into a specialty court. Are you in the drug court yet? Have you met with them yet?
Yeah.
Okay. What's the court cost? $1,290. So once you start paying $50 a month on that 30 days from today, you got an extremely lenient deal here. With all these things that are going on, I looked at your record. You need to work really hard on that drug court because the recidivism rate for someone that has to pass in the record you do is really big. So you're gonna have to work on it really hard because I don't like to send anybody to penitentiary. I will send you, okay? Especially if you're out in a vehicle driving around. Two things that really get on me is people on probation or on bond. They're out driving vehicles or having guns. The combination of drugs and guns and driving a vehicle are not good for you or anybody else. So meet with a probation parole officer, okay? And you start paying that the court costs and fine. Okay?
Judge, it's a matter of procedures. You want to cover the DUI guilty plea form in this round. That's what
Yeah,
I'm
you realize that's enhanceable. You did when you entered the plea, right? If you get another DUI.
Thank you, Judge.
Yeah. Pardon? I said $60, is it $50? I think I said 50. 30 days, the probation parole officer is there. Thomas Carson. Thomas Carson. Did you ever hear back from the lab person?
We just pick it up.
November 30th. November 30th. Is she available for then? What are some other dates she has in November?
As long as we pick a day, the lab will be available.
Do what?
We just pick a day and the lab will be available.
They
This
will?
lab examiner is not very good.
Back.
We were hoping for something in December.
Well, I want to get this. I've got a bunch of stuff coming too, and I can't, we got murder trials and we got other things like that, and I can't be letting possession trials tie a whole week up on me. I've got to get this trial. So we'll go down through there and find a date to accommodate you, okay?
Yes, Your Honor.
What about December 1st?
We have a negotiation day in Clinton County that day.
What'd you say?
We haven't negotiated and scheduled that day, Your Honor.
You have a Clinton County trial scheduled on the 27th, correct?
I'm sorry, what month, Judge?
November 27th.
No, we don't have anything scheduled.
I had Commonwealth versus Richardson down there.
Very pleased.
He's gonna interplay today.
Okay, well, let's just. What about the 27th, Monday, the 27th?
That's it. It's not a phone.
If I can check with my partner who was covering the Richardson trial when he gets here, since he won't have that trial. He's
Okay.
gonna let Dave, but
Let's just set it that day. Great. See you on November 27th. We did Thomas Carson. Commonwealth versus Thomas Carson.
That's me, sir.
Who are you, man?
He doesn't hear very well, so he doesn't hear something I'll learn.
No, get him the earphones. You need to go back. Can you hear that, Mr. Carson, now?
Yes, sir.
Okay. Commonwealth versus Thomas Carson, 23 CR 00104. You're here today for the purpose of arraignment. You're representing the district court by the Office of Public Advocacy. I'm representing Mr. Pennington, Mr. Pennington to continue that representation. You're here, you have a right to remain silent. Here you go, Henry. Thank you. Okay. You have a right to remain silent. The grand jury of Cumberland County has returned an indictment charging you with wanton endangerment in the first degree and operating a motor vehicle under the influence. You understand those charges?
Yes, sir.
Okay. Counselor, you acknowledge the identity of your client, receive indictment, waive formal reading and arraignment, enter plea not guilty, reserving all pretrial motions.
yes, Your Honor.
This will be here back on December the 21st. When is your negotiation day? December
December 15th.
15th, 9 a.m. You'll be back here December 15th at 9 a.m. for negotiations, and for December the 21st, your next court appearance. Both of them are conditions of your bond. I've signed a reciprocal discovery order where the Commonwealth will give your attorney information you need to prepare your case, okay? Thank
Yes,
you very much. Kevin Cooper. Commonwealth versus Kevin Cooper, 23 CR 0073. Are you Kevin Cooper?
Yes, sir.
You were born in 1997.
Yes, sir.
Last four digits of your social security number are 9637. Is that correct?
Yes, sir.
Here today for the purpose of arraignment, you're represented by Mr. Poindexter. You have a right to remain silent. The grand jury of Cumberland County's returned an indictment charging you with possession of controlled substance in the first degree, methamphetamine, possession of drug paraphernalia, failure to maintain insurance on a motor vehicle, failure to signal, failure to eliminate your registration plates. Mr. Baylor? Mr. Poindexter, you acknowledge the identity of your client, receive the indictment, waive formal reading and arraignment, enter a plea of not guilty, reserving all pretrial motions.
We do, Your Honor.
Sign a reciprocal discovery order. Mr. Cooper, that will require the Commonwealth to present certain evidence they have your attorney get to carry your case. You shall next appear here on the 15th of December for a negotiation day and on the 21st of December for the next court appearance. Okay, continue the same bond.
Thank you, Your Honor.
Sherry Coat. Pass over her, come back. For the Commonwealth's purpose, evidently she was involved in an incident where she had a passenger that coded in a vehicle. So is she here?
That's correct, Judge.
Never mind that.
She did make it.
Commonwealth versus Sherry Cody, 20 CR 0041. Ms. Cody, were you born in 1976?
Yes,
Last four digits, social security number 7839.
sir.
You're here on a pretrial diversion revocation. What does the Commonwealth have to say?
Your Honor, we need to have a hearing.
What are the allegations?
Use of controlled substance methamphetamine, use of controlled substance marijuana.
You want to stipulate that or do you want to hear it?
She stipulates to that, Judge, she admitted to both.
Okay. What does probation and parole recommend in this thing?
We referred her to the social services clinician for substance abuse treatment, assessment and treatment. Ms. Cody was directed that failure to comply would result in increase in substance abuse treatment. The social service clinician referred her to outpatient treatment at RJJ. She was subsequently transferred to the London office and is currently being supervised by an officer, Brian Morgan, out of that office.
Were those the only violations she had, the use? That
Yes, Your Honor. She did admit to them. I signed an admission of guilt form.
Did you lodge her?
I did not lodge her because we referred her to the social service clinician to get her treatment.
Well, I'm going to keep this pretrial diversion revocation motion under advisement. I'm going to rule on it. But if you have anything else, I'm going to revoke the pretrial diversion and have pre-sentence investigation for it. I need to be a convicted felon. You understand that?
Yes, sir.
You need to stay off this stuff. If you've got any problem, work with that clinician. Are you driving now today? Did you drive here?
I did today because my driver stopped breathing on the way. Actually, we stopped at the store for gas and she had a heart attack or what. But I mean, I'm driving some, yes. And I do have appointments set up with RRJ. I've done my intake and I've had a couple.
When is that?
Well, I had a one-on-one yesterday. I start the IOP group, I think on Monday, this coming Monday.
Is that okay with the Commonwealth?
That's fine.
And I have,
Don't violate anymore, you hear?
absolutely.
Okay, thank you.
Thank you.
Just for the record, since she is enrolled in RJ, and I do have proof if you would like. Please
I'll
see
take
that.
your word for it.
Thank you, Judge.
Brett Davis.
Good morning, Your Honor.
Mr. Davis, can you see us here?
Yes, sir.
Okay, Commonwealth versus Brett Davis, 23 CR 0028. Mr. Davis, is your year of birth 1994?
Yes, sir.
Last four digits of your social security number 2736.
Yes, sir, Your Honor.
Okay, what does the Commonwealth have to say in this case?
Your Honor, they've been through negotiation. I think we're down to set the trial date.
We're resetting the trial, Your Honor. It had to be continued, so we're here just to get another trial date today.
What is the charge?
Your Honor, this involved basically it's theft. He took a contract to build a house, didn't get much work done, and
That's enough.
there's an issue.
Y'all ready to go to trial?
We're ready.
What about November 30th?
I'm out, well, I'm back by then, but that is, Your Honor, for.
Your Honor, we're gonna need more time than I'm sorry.
Okay,
They're traveling nurse and this person has a schedule from. And need to, 30 days, yeah.
how much time do you need to bump it out?
Probably January, Your Honor.
What about December 18th?
Your Honor, I've got numerous obligations already that day.
It's a Holland case. Are you involved in the Holland case in Clinton County?
All
Commonwealth versus Holland.
I am, Your Honor.
It's Mr. Pennington's case.
Is they gonna go to trial?
No, Your Honor.
Judge, we have motion that they.
Yeah, that's right. We mentioned the 12th,
We're closed on
December 12th.
yes. The governor's inauguration. They sent out an email. So directed how to use our leave time or how to do our time sheets for it.
See the email, so that we're.
Says Chief Justice Van Meter has announced the judicial branch, joint executive branch, and closing for business on Tuesday, December 12th, 2023, to observe the inauguration of Governor English.
Is it a big it's gonna be a big holiday in Manchester. Never mind. Black ones. Did you say you had something on November 30th?
Yes, Your Honor. Commonwealth said they couldn't do a thing.
How about December the 28th? That out.
See if they do it that day, Your Honor.
Okay.
All right, we'll need to check with the victims on that, make sure.
Well, that's
Try to
quite a
call,
bit.
try to call them right now, or
I'm gonna say it on December 28th. Okay.
Will it just take one day?
Yeah.
We previously had it set for 2, but we're closing.
We'll just take one day. Great. Joshua Duval.
Your Honor, the Commonwealth request a hearing.
Commonwealth versus Joshua Duval. 23 CR 003. Are you Joshua Duval? Yes. Represent the Office of Public Advocacy. Born in 1985. Last 4 digits Social Security number 4641. Yes. You have pretrial aversion revocation. What is the allegation?
Your Honor, the current violations are failure to cooperate with probation officer, failure to report positive test for methamphetamine, positive test for THC, and failure to complete treatment.
We're hearing. Here. And stipulate.
Yes.
Let's stipulate. Now, what, could you just go over his record generally, but before that? No, just about since it's been under your supervision.
Okay. On June 30th, 23, he had a positive test for methamphetamine and a positive for THC. We sent him to outpatient. On July 7th of 23, he had another positive test for opiates, denied use. We lab confirmed it. We charged him with a violation for providing false information for lying about the use of opiates. We moved him to moderate reporting and continued his outpatient because he just started. On September 15th, he had a positive test for methamphetamine, oxycodone, and THC. He admitted to all three of those. We moved him up in level of treatment from outpatient to IOP. On October 30th, he had another test for positive for methamphetamine. We allowed him to continue IOP because he's allowed one positive test without being discharged. On November 13th, he failed to cooperate with probation and parole based off of a community complaint that I received. He failed to cooperate with that investigation. He failed to report on November 2nd. And then when we did make contact with him, he was positive for methamphetamine and THC. He initially denied that he was positive, and then later admitted to after the test proved positive. And then he was discharged from IOP for failing for his second positive test during participating in IOP.
What do you have to say about this?
Judge, sounds like Mr. Duvall needs some treatment, some significant treatment.
Well, I'm going to revoke his pretrial diversion order and pre-sentence investigation report, be under probation and parole, and be here on December 21st for sentencing. And you're in the custody of the jailer. Maybe we can get your attention. Up to this point, we haven't gotten your attention. And, you know, I just don't want to pick up the newspaper and find you something wrong with you. So you're in the custody of the jailer. And then maybe we can find some placements or something to find in. Maybe we can work on something.
Yes, Your Honor.
Ashley Dyer. Commonwealth versus Ashley Dyer, 21 CR 00013. Are you Ashley Dyer?
Yes, sir.
Okay, you're here today on a pretrial diversion revocation. You were born in 1988.
Yes, sir.
Last four digits of social security number 2417.
Yes, sir.
Okay. What does the Commonwealth have on this?
Your Honor, request hearing, please.
What?
Judge, actually, if I may, we were last time, we actually referred Ms. Dyer to specialty court. This morning, she was actually voted and accepted into specialty court in lieu of revocation. Judge.
That's correct, Your Honor.
Okay. When do you have your orientation?
He didn't say.
She just completed her waiver executed this morning, so I would hopefully soon. I don't know that today was her first orientation day.
Did you meet with the drug court today? You were in the room
Yes,
there,
sir,
so
yes.
you're already in, sounds like.
Yes.
Yeah, okay. Okay, well, you just need to, avoid any problems there.
Yes,
I
sir.
mean, they're pretty tough supervision, but it's the best opportunity you have to remain free.
Yes, sir.
Okay,
Thank you, Your Honor.
thank you. Anna Gail Harley. Anna Gail Harley.
I got a call yesterday.
Commonwealth versus Anna Gail Harley. Are you Anna Gail Harley?
No, sir, but I'm the
Okay.
closest thing here to her, because I'm her attorney of record. I have filed an entry of appearance yesterday afternoon. Miss Harley called me yesterday, said she had received some sort of something on her phone about a court date today. I said, have you been served with papers? She says, no, I can't get there. Talked to Mr. Stockton, if we could pass this case to December, we'll have her here. She's out of state.
Already active warrant on her?
Yes. I've moved for that to be recalled if I can bring her in.
She need to be here today.
Well, Your Honor, she's not been served with the warrant. I'd have to
Well,
put that out.
well, let me tell you, there's a warrant out there for her. When we find her, they'll serve it on her,
That's
arrest
exactly
her, and
right.
she'll be here
But
next
if
time.
she's not been served today,
Well, let me tell you something. I'm not gonna get into business where people have active warrants out and call an attorney to come in here and say, well, I can't be there today, put it off for a month. She needs to turn herself in. So there's an active warrant out for her.
That's
When
fine.
they find her, I'll take care of it.
that'll be fine, Your Honor.
Yeah,
We'll
and you'll
do that.
know where to find her.
I have her phone number, I do.
Okay, thank you. Commonwealth versus Dallas Hayes.
served last night, so he's in custody. He can do it.
Okay, he'll be on the jail docket. He was. Okay. Tyler Holland,
He's on Zoom.
Clinton County case. Why is Mr. Holland on Zoom here?
He's the one who had to work and you gave him permission to come on Zoom.
Yeah, that's right.
The documents.
Copy of the motion.
Well, this is Clinton Circuit Court meeting a special session in Burkesville pursuant to an agreement. Are you Tyler Holland? You need to put your microphone on, Mr. Holland. Are you Tyler Holland? Turn your microphone on. There's a little microphone looking thing, an ancient microphone looking thing. This is why I don't let people.
Can you
There
hear
you
me
go,
now?
Tyler.
There you go. You were born in 1996.
Yes, sir.
Last 4 digits, social security number 0698.
Yes, sir.
You're here today for pretrial conference on 23 CR 0040. I understand that we have a plea today. Is that correct?
That is
Yes.
correct, Judge. The plea paperwork unfortunately is in Clinton County. I thought it was gonna be faxed over here. As it being Clinton County.
You have a
case.
copy of it, don't you?
Yes, I do.
Okay, is this a felony plea?
Yes, Your Honor.
Okay, I want you to listen very carefully. A motion's been tendered, says that you wish to enter a guilty plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes, sir.
Are you the same individual named in Clinton Circuit Court 23 CR 0006?
Yes, Your Honor.
No, 23 CR 00040. Rather.
Yes, sir.
Is your judgment impaired today?
No, sir.
Okay. Have you discussed these charges with your attorney and are you satisfied with his advice?
Yes, sir.
Have you reviewed the evidence which Commonwealth has against you?
Yes, sir.
You believe you've been fully informed about your case?
Yes, sir.
You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky United States Constitution. Before I can accept the plea, I need to know you understand those rights.
Yes, sir.
I'm gonna go over them, and then at the end, I'm gonna ask you if you understand. You have a right not to testify against yourself. No one can make the same thing. Right to speed trial by jury, right to be represented by counsel at jury trial, the right to confront and cross-examine all witnesses called to testify against you, the right to produce evidence, the right to call witnesses in your favor, the right to appeal this matter to higher court if you lose, the right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of the charges against you. By entering a guilty plea today, you give up all those charges. You understand that? All those rights, rather. You understand that?
Yes,
I may
sir.
consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. I don't have to accept the recommendation. Prior to accepting the recommendation, I will await the pre-sentence investigation report on probation and parole. In the event I don't accept the Commonwealth's recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea and go to trial. You understand that?
Yes, sir.
And what is the Commonwealth's recommendation, Mr. Gordon Anderson?
On a plea of guilty to trafficking in a controlled substance, first degree, first offense, class D felony.
Wait just a second. That's not him. Cameron, you have to go and speak louder.
Okay. Upon a plea of guilty to trafficking in a controlled substance, first degree, first offense, a class D felony, the defendant shall receive a sentence of 4 years. Upon a plea of guilty to tampering with physical evidence, the defendant shall receive a sentence of 4 years. The 2 4-year sentences shall run consecutively for a total of 8 years. Serve 180 days home incarceration with the balance probated for 5 years supervised. The defendant shall be permitted to attend church, doctor's appointments, and employment. Home incarceration activation shall be determined by the court if not already in place. Defendant shall receive credit for time served and shall obtain gainful employment or do a minimum of 30 hours per week until gainful employment is obtained. And the defendant agrees to have any and all evidence destroyed in a manner that is consistent with the laws of the Commonwealth and the holding agency.
Is that what you agreed to, sir?
Yes, sir.
Now, is your client on an ankle bracelet now?
He is. Tyler, you're not on an ankle monitor right now, are you?
No, sir.
No, Your Honor.
Okay, well, he'll need to be on the ankle monitor by the end of business tomorrow. When do you want him to come see probation parole?
He's report to the Monticello office tomorrow at 9 a.m. to meet with Officer Christy Clooney.
What'd you say? Yeah,
Okay.
hear that? 9 a.m. in the morning.
Yeah, what about the ankle monitor? When was that?
Do what?
When's the ankle monitor supposed to be done?
Well, you call your attorney, he'll give you, it'll be by the close of business tomorrow.
Okay.
I'll give you a call today,
About
Tyler.
4 o'clock tomorrow. Now, are you, have you had plenty of time to discuss this matter with your attorney? Are you satisfied with his advice?
Yes, sir.
You're pleading guilty because you are guilty of the acts contained in the amended indictment. Is that correct? You realize that any future convictions of felonies could be enhanced as far as the range of penalty because of your plea today.
Yes, sir.
You have signed this plea agreement. Is that correct?
Yes, sir.
I'll accept the plea agreement, order a pre-sentence investigation report, and come back December 21st for sentencing. Is that correct?
Judge, do you want to do that in
What's the date?
December 11th?
December 11th. You come back to court in Albany on December 11th for sentencing. And when you get this ankle bracelet on, those days will be good. So you know
Okay.
what I'm saying?
Thank you, Judge.
Okay, thank you. Billy Huddleston. Is there an active warrant out for Mr. Huddleston?
I think we want the process.
Do what? Commonwealth versus Billy Huddleston, 23 CR 00101. Mr. Huddleston, were you born in 1962?
Yes, sir.
Last 4 digits, social security number 3418. You're here today for the purpose of arraignment. Represented by counsel, you have the right to remain silent. The grand jury of Cumberland County has charged you with possession of a firearm by a convicted felon, driving on a suspended driver's license, criminal trespass, 3rd degree, operating an all-terrain vehicle on a public road, being a persistent felony offender. You understand those charges? Counselor, you acknowledge the identity of your client, received indictment, waive form, wording, arraignment, enter plea of not guilty, reserving all pre-trial motions.
Yes, Your Honor.
What was the bond I set on this case? Do what?
It was I'm sorry. It's 25,000 cash property and it's another posted form.
And you're under the restriction of staying at home, work, church, or the doctor, correct? You also not having firearms in the house you're located. Where you living? Okay, well, you be back here. The negotiation day is December 15th here at 9 o'clock and be here on December 21st, your next court date, both of them conditions of your bond, okay? Concepcion Lopez. Okay, now I have Commonwealth versus Concepcion Lopez.
We need to interpret the judge. I'm not sure. Mr. Bruce Brown here? Ms. Rivera's attorney, Mr. Brown, who's not here, was supposed to have his interpreter on Zoom. I don't see either one of those.
Do we have an interpreter on Zoom here? Mr. Pennington, are you having a discussion with your client?
I'm getting some contact information, Judge.
That doesn't bode very well for his need of an interpreter. Right along here. Mr. Pennington, do you believe your client is linguistically able to participate today?
Judge, I think he's trying to show me people to contact that might be able to help him, but not, I don't know about today.
Yeah.
So,
Well, this is lucky day. Having to be back here on December the 21st, and I want a negotiation day.
December 15th.
December 15th. You give him a card here. You give him a card, anybody give him a card. Let's make sure we have an interpreter that day. Jerry McClister. Jerry McClister.
That's important.
Commonwealth versus Jerry McClister, 23 CR 0077. You, Jerry McClister, born in 1965. Last four digits, social security number 8984.
Yes.
You're on a pretrial conference. What do you have?
Judge, I think this is one, we had made a counter offer to the Commonwealth and hadn't received a response on that just yet.
Plea offer was emailed Monday, 10/23.
No, it's a conversation since.
What is the charge in this case?
Judge, there's a possession of controlled substance and a driving while under the influence. Just put a little clarity, Mr. McCluster actually had his own medicine, and we've provided copies of his medicine to the Commonwealth. And granted, he has taken accountability and is willing to enter a guilty plea to the driving under the influence. It's the possession of his own
What was
medicine.
the possession of
Hydrocodone.
prescribed medication?
Yes, Your Honor.
Did the officers do a pill count or anything on it?
Oh,
What's the Commonwealth have to say?
We thought we had a plea deal and then fell through. Right. Or never did. The note I have says in the plea.
Well, when we were here last time, I indicated that I wanted my firm's lab technician to take a look at Mr. McCluster's labs with regards to the driving under the influence. Conceded that point, but did not concede the possession of his own medicine.
Okay. How about another negotiation?
December 15th and December 21st. Cheryl Profit. Commonwealth Kentucky versus Cheryl Profit. 23 CR 00100. Are you Cheryl Profit? You born in 1966?
Yes.
Last four digits, social security number 1603. You're here today for the purpose of arraignment. You're represented by counsel. You have a right to remain silent. Grand jury oath. Cumberland County has returned an indictment charging you with assault in third degree. You understand that charge?
Yes.
Okay. Mr. Cross, you acknowledge the identity of your client, received the indictment, waive formal reading and arraignment, entered in plea of not guilty, reserve all pretrial motions.
Yes, Your Honor.
Okay. Mr. Prophet, I'm signing a reciprocal discovery order to give you the evidence, some of the evidence Commonwealth has against you to help you prepare your case. You be available for negotiations on December 15th here at the Justice Center, and your next court date is December the 21st. Okay. Thank you.
Your Honor, there's one provision of the bond that I've discussed with the Commonwealth, which.
Well, we actually haven't discussed the details of it. You simply said you had an issue, and I don't know what the issue.
Court's basically issued its semi-standard order where she's not to travel other than to work and stay home and such.
Church.
Right. And Your Honor, Ms. Prophet is, I don't guess she's ever been in court for anything. This is she's employed at Monroe County Medical Center, been there for years, and don't think that that would be.
Well, what restrictions do you want lifted?
I don't think she needs it. I would think it would be appropriate to lift all travel restrictions, Your Honor. She's made a substantial bond.
Well, she also is accused of slapping the sheriff of Cumberland County.
Well, Your Honor.
Well, that's what the accusation is, and that's assault on a police officer. I don't know whether she's guilty or not guilty, but she got the same bond issues. Now, if she's got someplace she needs to go or whatever, she can get permission and go. I'm not going to restrict her.
Permission from who and when, Your Honor?
She just needs to call the Commonwealth. Y'all reach an agreement.
This Prophet need to do that on every.
I'm not going to, let's just forget I said that. Because I can see she's going to be calling over there every day. You have her here on the 15th and the 21st. Okay.
Thank you, Your Honor.
Yeah. Janessa Smith. Commonwealth versus Janessa Smith, 23 CR 0068. Are you Janessa? Where is Janessa Smith?
Judge, there's an active one. I think this is a motion regarding the surety, so it's not.
Sure, you're requesting come off the bond. Where is the surety? The problem is you cannot come off a bond while they're fugitive. Once they take her back into custody, you can come off the bond. If everybody wanted to come off a bond when somebody didn't show up, there would be a reason to have a bond, wouldn't there?
She's not house now.
Do what?
She's not house now. Get somebody to pick her up today.
Where is your house?
Yes, yes, I got
Have her come on up here. Call her and tell her to come up here. Somebody want to talk to her. That's true.
That is true.
Yeah.
Several.
And when she comes, take her in custody for FTA.
Yes, sir.
Keith Smith. Mr. Cross. Commonwealth of Kentucky versus Keith Smith, 23 CR 0024. Is Mr. Cross back there anywhere? We're here for a pretrial conference.
Yes, Your Honor.
What's the Commonwealth have to say?
I believe, Your Honor, we're waiting on a ruling on a motion to suppress.
Correct.
Where we at? We have a hearing on it.
Yes. I believe it was in August.
I'll have to look.
You remember, I'm just, you
No.
remember that.
I say I'm not familiar with it. I'll have to.
Yeah, okay. I didn't hear that part of it. Okay, we'll just reschedule this. Are you gonna do negotiation? Is this a dog? Is this a dog case? Is this
No, this was there were two issues. I don't believe there was a dog. There was question of stuff and question of the extension of the stuff, but I don't believe it was a. I think it was a dog. No.
Did y'all file briefs on this?
Yes, sir.
You got your brief with you?
I've got it on line. I emailed.
Let me look at the briefs. Maybe refresh my memory on it. I remember now. We'll get you a written ruling on it. If we deny your motion, then you be down for negotiations on the 15th.
Thank you.
You understand what I'm saying? If the motion to suppress is denied, y'all have the 15th and the 21st. And then if we sustain the motion to suppress, then you'll have to inform Mr. Cross on the 15th and 21st whether you wish to proceed or not, okay?
Thank you, Your Honor.
Jamie Stearns. Barron County, we just have about 4 more cases. We'll be right to you. Jamie Stearns. Commonwealth versus Jamie Stearns. Are you Jamie Stearns?
Yes, sir.
You were born in 1977.
Yes, sir.
Last 4 digits, social security number 4748.
Yes, sir.
Are you represented by an attorney?
No, sir. This first time here.
Have you filled out an affidavit to see if you can afford an attorney or not?
No.
Come over here and fill out an affidavit. James Walls. James Walls. James Walls. Issue a bench warrant. Cody Willis. There's an active warrant out. Y'all look at NCIC.
Judge, I think there was also, this was Commonwealth's motion for status regarding the trial we have scheduled for next week.
But it says there's an active warrant for him.
There is.
That's my understanding, Judge, that Mr. Pennington hadn't been able to get in touch with his client. There is an active warrant.
I don't anticipate him being here for trial, Judge.
Well, they might catch him between now and then.
But I think the Commonwealth has some out-of-state
I have an
witnesses.
out-of-state victim in this, Judge. I really need to know today if we're gonna have a trial Tuesday or not.
What is the charge?
Well, it's multiple charges of theft, which involved into possession of a handgun by a convicted felon. A search warrant involved from that.
What date's the trial?
Tuesday,
Next
next
Tuesday.
Tuesday.
You tell me you hadn't had the opportunity to prepare for the trial too then.
That is correct, Judge.
So I'm gonna continue the trial and issue a bench warrant for him.
Already went out
Let
there,
me finish.
but I'm sorry,
I
Judge.
want a bench warrant with a $250,000 cash bond. Okay, thank you. Try NCIC. That case is continued. Jennifer Wise. Commonwealth versus Jennifer Wise.
Back on Mr. Willis, there's already an FTA warrant with no bond and a bond violation warrant with no bond.
What was one other warrant? Okay, just leave it with the no bond. Commonwealth versus Jennifer Wise. Is there a warrant out on Miss Wise? When? Yeah, okay, I just had it on here. Are you represented by the Office of Public Advocacy? Okay, the grand jury of, you have a right to remain silent. The grand jury of Cumberland County has returned an indictment against you. Were you born in 1980?
Yes, sir.
Last four digits, social security number 7617.
Yes, sir.
You're on 23 CR 0013. The grand jury returned an indictment charged you with possession of controlled substance, first degree possession of drug paraphernalia, possession of marijuana, failure to maintain insurance, and failure to use your seatbelt. You acknowledge the identity of your client, received indictment, lay formal reading room, and therefore you're not guilty, reserving all pretrial motions.
Yes, Your Honor.
Sign a reciprocal discovery order. Just so they'll provide you with information. You'll be for negotiations here on the 15th of December, and the next court date's on 21st. Both of them are conditioned to bond. You understand that?
Yes, sir.
Okay, thank you very much. Cinda Young. Commonwealth versus Cinda Young. 23 CR 0079. Are you Cinda Young?
Yes, Your Honor.
You were born in 1959.
Yes,
Last four digits, social security number 6221.
yes.
Okay, here for pretrial conference. What does the Commonwealth have to say?
Another negotiation back.
Be here for December 15th for negotiation, next court appearance, December 21st. Okay,
Thank you.
See you.
okay, did Jamie Stearns get here? Did we do Jamie
I think
Stearns?
he completed the
Getting
application.
interviewed now, okay. Dallas Hayes is in jail. John Richardson. It's a Clinton County case, supposed to be here. What's your name? Well, we thought you were in free somewhere.
He's still in and around. He said it'd be about 30 minutes.
The attorney?
Yes,
Okay. Okay, you can have a seat there. Who is the attorney on this?
my partner. There was a conflict. I represent the co-defendant and Mr. Richardson, or representing the co-defendant, Mr. Richardson.
Y'all have a deal on this case?
I think so.
Okay, let's go to Barron County Jail. Barron County, are you on there?
Yes, Your Honor.
Hey, sorry we're a little late. We don't usually do that. So, got a Monroe County case, Stephen Bray. Commonwealth versus Stephen Bray, 23 CR 0031. Are you Stephen Bray?
Yes, sir.
We're here at meeting here in Monroe Circuit Court by agreement. You were born in 1970.
Yes, sir.
Last four digits of your social security number are 0058.
Yes, sir.
Here for a pretrial conference. What does the Commonwealth have to say in this case?
We have a felony plea, Your Honor.
A motion's been tendered, Mr. Bray. It says you wish to enter a plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes, sir.
Are you the same person named in Monroe Circuit Court indictment number 23 CR 0031?
Yes, sir.
Is your judgment impaired today in any way?
No, sir.
You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky and United States Constitution. Before I can accept the plea, I need to know that you understand those rights. But before that, have you had plenty of time to discuss this matter with your attorney, and are you satisfied with his advice? Okay. Now, the rights you have, I'm going to go down through, and when at the end, I'm going to ask if you understand. You have a right not to testify against yourself. No one can make you say anything. Right to speedy trial by jury, the right to be represented by counsel at jury trial, the right to confront and cross-examine all witnesses, call testify against you, right to produce evidence, right to call witnesses, and have process issue, compel their attendance. You have a right to appeal this matter to higher court if you lose, right to apply the Commonwealth, prove on a reasonable doubt that you're guilty of the charges against you. By entering a plea guilty today, you give up all these rights. You understand that?
Yes, sir.
I may consider the Commonwealth's recommendation that I may apply the range of sentence provided by law. I don't have to accept the recommendation. Prior to accepting the recommendation, I'll have a pre-sentence investigation report done by probation and parole. In the event I do not accept the recommendations of the Commonwealth, decide to impose a harsher sentence, you'll have, you can reject the plea. I'll reject the plea agreement, and you can withdraw your plea and stand trial by jury. Okay, you understand that? What is the Commonwealth's recommendation?
Upon a plea of guilty to strangulation first degree, the defendant shall receive a sentence of 7 years with the balance probated for 5 years supervised. As of the entry of this plea, the defendant has served 90 days in jail. The defendant shall remain in custody until final sentencing and up until the morning of his rehab bed date at the Mark Center. The defendant shall re-enroll in rehab and complete rehab at the Mark Center in Bowling Green, Kentucky. The defendant shall obtain anger management counseling and shall provide proof of enrollment and completion to probation and parole. The defendant shall follow any and all recommendations of this mental health providers and submit proof of compliance with probation and parole. The defendant shall have no contact with the victim. The defendant shall receive credit for time served and shall obtain and maintain gainful employment or do a minimum of 30 hours per week until gainful employment is obtained. And the defendant agrees to have any and all evidence destroyed in a manner that's consistent with the Commonwealth and the holding agency.
Is that what you agreed to, sir? Mr. Bray, is that what you agreed to?
There was one change in there, I think. My attorney changed this morning. I don't know if he had showed it to Commonwealth or not. It's about the no contact with victim. It's supposed to be no violent contact with a victim because it is my wife.
You said no contact.
Yes, I believe you said.
That's Judge, in light of not being able to get in contact immediately with the victim, I don't think we can make that concession, Stephen, or change, Stephen.
Well, I accept the offer.
And so you go ahead and accept the offer the way it is. And if he wants to modify that at some time, if the victim will contact the victim's advocate and come in, then we can modify it after review.
And given he's going to rehab, I think there'll be some time before that.
Are you entering a guilty plea because you did actually do the acts in the amendment as in the indictment as amended?
Pardon, sir?
Are you entering a guilty plea because you did commit the acts in the indictment as amended?
Yes, sir.
Okay. Are you satisfied with your attorney's advice?
Yes, sir.
Knowing your constitutional rights I've explained to you is still your desire to give up those rights, enter a plea of guilty, and allow the court to fix your punishment. Now, do you understand that any future convictions of felonies under guilty pleas or convictions, your range of penalty could be enhanced because of this plea here? Do you understand that?
Yes, sir.
Okay. Do you have the document he signed? Is that your signature right there, sir?
Yes, sir.
Okay, well, I'll accept the plea and order a pre-sentence investigation report done. And we'll be back here in December.
And Judge, it's my understanding that Mr. Bray has already completed his PSI paperwork, and we've been in contact with Officer Collins. Is there any way we could schedule Mr. Bray's sentencing for the Clinton date, December 11th?
Commonwealth have any objection to that?
No.
Okay, we'll schedule it on December the 11th for sentencing in Clinton County, okay?
Thank you, Judge.
Thank you. Johnny Gold. Johnny Gold. Commonwealth versus Johnny Gold. 21 CR 0023 for sentencing. Are you Johnny Gold? Mr. Gold, were you born in 1973? I can't hear you, Mr. Gold. It's voice activated. You gotta say something, okay? You were born in 1973?
Yes, sir.
Okay. Last four digits of social security number 7682.
Yes, sir. Sir.
Your attorney, Mr. Poindexter, is present. Mr. Gold, have you had an opportunity to review the pre-sentence investigation report again, done by probation and parole?
Yes.
Okay, is Mr. Poindexter, did y'all find it substantially correct?
Yes, Your Honor.
Is there any reason this gentleman should not be sentenced?
No, Your Honor.
Okay, his pretrial diversion was voided on 8/31/2023. Pre-sentence investigation report was done. We sentenced him to 3 years, okay?
Yes, Your Honor.
Okay, thank you very much. Amber Huff. Commonwealth versus Amber Huff. Ms. Huff, this is 22 CR 0079. You're here for sentencing. Do you understand that? If you had an opportunity to look at the pre-sentence investigation report done by probation and parole,
Yes, sir.
is it substantially correct?
Yes, sir.
Counselor, is there any reason why this lady should not be sentenced today?
Your Honor, there's no reason she should not be sentenced. There was one correction that we noted that we do feel is substantial enough to want probation and parole to take a look at. They had listed prior court contact and listed a juvenile case on there, Your Honor. And since it's a juvenile case, I'm not going to announce it to the room. We believe, one, a juvenile case shouldn't be entered on a PSI because it should have been sealed, and two, that was not accurate, that it's not her. So we would just ask probation and parole to take a look at that.
Well, I'll order it deleted if that's the case, okay?
Thank you, Your Honor. Other than that, Your Honor, no objection to that.
Upon plea of guilty to complicity of theft, unlawful taking, or disposition over 10,000, she shall receive a sentence of 10 years. The defendant shall pay restitution jointly and severally with other co-defendants, Ryan Moore and Austin Brown, $23,125, subject, of course, to clerk's fees, paid to restitution. Court cost amount of 185.
Your Honor, would the court consider waiving those given the length of her sentence? And that hefty amount of restitution that she'll start paying as soon as she's released?
I'll just wait till she gets released. We'll take a look. 185. Is that what you said it was? Madam Clerk? What was the amount of restitution?
The total restitution fee is 24,466.
I don't
The
know.
restitution.
No, I just want to know what the court cost is. I already said what the restitution is.
The court cost is 185.
185. She can start paying it $30 a month, 30 days upon her release. Okay, thank you very much. Monroe Circuit Court case, Edward Whitledge. Combo versus Edward Whitledge, 20 CR 0085. Are you Edward Whitledge?
Yes, sir.
Were you born in 1991?
Yes, sir.
Last 4 digits, social security number 9864.
Yes, sir.
Monroe Circuit Court case, meeting by agreement here in Cumberland County. And it appears by agreement on Zoom. What do we have to do here?
The Commonwealth's filed a motion for a trial date in this case, Your Honor.
You need to speak up just a little.
The Commonwealth's filed a motion for a trial date. And I know the defense counsel wants to mediate. I don't know if you want to set the trial date and then mediate during the pendency or what you want to do. But I'm looking several months out because there will be some out-of-state witnesses on this.
We are in agreement to mediate, Judge. I'd ask the court to go ahead and order the mediation today. If we do set the trial date, I would just ask that it's set out towards the end of next year.
That's a little farther than I was wanting, but I was thinking more like the summer.
What would
late
be
spring.
the need to set it on the end of next year?
Ms. Hines has a death notice case set for trial during the entire month of July. So she will be unavailable in June when she's preparing for that trial and then in July. So we would be available to try the case after that. But she would need at least a month after that trial before we could be prepared.
You're talking about sometime in July.
She'll be in trial in July, so we would
Oh,
ask.
in trial in July, okay.
Right, so we would be asking for September or October.
How many days you anticipate this?
Well, if it's not a death case, I would
speak up.
I would think if it's not a death case 5, it's the death case 30. I'd say that would be my guess. Now, I can't answer that question until after the mediation.
Well, what I am inclined to do in this case is start it on a Monday of some month while we're in Monroe County.
Okay.
See what I'm saying? While we're there for our rule day. That way we'd have 3 good days in. We could shorten our rule day on that day if possible. Just hear what's necessary and then pick up the rest of that day and pick up Friday. That'd give us a whole week.
So you're looking like something like September the 16th. Then.
That's what I would be looking at.
Yeah.
Probably,
We're in Monroe County on the twelfth, so you'd want to start it on the ninth.
Oh, I looked at, I looked at
the
Cumberland
ninth,
County. That's
September
right.
the ninth.
Thank you.
Let's set it for September 9th.
Are you going to prepare the order on the mediation? Okay. Yes.
Is that September 9th? Do y'all have any preference as to who the mediator is?
I think Judge Patton does a good job myself, but whoever you want.
If we could discuss that, Judge, and I can name the mediator that we've agreed on in the order I submit.
It'd be fine.
Great, thank you.
Thank you.
In Barron County, do you have anybody else waiting to see us over there?
No, you're all right.
Okay, well, thank you very much.
Your Honor.
Grand jury adjourned. Okay, could we clear this area here off? And, sir, would you move back into the crowd there somewhere? And you need to move this lady back into a cell probably to get ready to go with it. You can bring the grand jury in. So I turn the camera off. You want to turn the camera off? I was afraid. Okay, are we back on? Jamie Stearns. And Mr. Stearns is eligible for appointment of public advocate. You're here today for the purpose of arraignment. Mr. Stearns. Mr. Stearns. Mr. Stearns, you've previously been identified by your birth and last word is social security number. You have two sets of indictments here. 23 CR 0098. Grand jury of Cumberland County has returned an indictment charging you with possession of controlled substance in the first degree, methamphetamine, possession of controlled substance in the first degree, hydrocodone, possession of controlled substance first degree unspecified, possession of marijuana, along with failure to maintain insurance. That is in 23 CR 0098. In 23 CR 00105, grand jury further returned indictment charging you possession of controlled substance first degree, methamphetamine, possession of drug paraphernalia, and possession of marijuana. Do you understand those charges? Do you acknowledge the identity of your client, received indictment, waive formal reading or arraignment, interplead not guilty, reserving all pretrial motions?
Yes, Your Honor.
Now, there are two separate indictments here. Are these two separate incidents that they need to keep separate numbers, or are you going to merge them? Is it one common incident or two?
No, they're two different.
Okay. If you'll come back here on the 15th of December at 9 a.m. for negotiation, and the 21st of December for your next court date. Both of those are conditions of your bond, okay?
Thank you, Your Honor.
Thank you. I guess we have Ms. Riviera here, correct?
Yes, sir.
Well, let me just say, is Bruce Brown here? Yes. Okay. Yeah, bring her out. Where's Johnny Bell when you need him? Where's Mr. Brown? Bruce Brown back there?
No, he went out that way, Your Honor.
Which way? Could you see if Bruce Brown, just announce Bruce Brown real loud? He might be in one of those side rooms. Commonwealth versus Maria Riviera, 22 CR 00106. Represented by, are you Maria Riviera?
Yes.
Okay, I understand Miss Riviera needs an interpreter, is that correct?
Yes, Your Honor.
There's not one here today.
I've arranged for the one that we've been using. She's a court certified interpreter.
She doesn't appear to be online.
She said 11, but she was gonna try to get on 11. She was in several other courts today. I just messaged her. Asked her to let me know.
Well, that'll be in 5 minutes. You just let us know when she's there, when she's available, okay?
Thank you, Your Honor. That's what I was gonna do.
Okay. Okay, let's go back, I guess. We finished in Barron County. go to Russell County. Russell County Detention Center, Commonwealth versus Darian Riddle. Are you Darian Riddle?
Yes, sir.
Are you Darian Riddle?
Yes, sir.
Okay, you're here for this, for sentencing. You're appearing from the Russell County Detention Center by agreement. Your attorney is here. Have you had an opportunity to look at the pre-sentence investigation report done by probation and parole? Have you seen the pre-sentence investigation report done by probation and parole?
No, have I seen? Yes, I've seen it. Yes. Yes.
Is it substantially correct? Is there anything you'd like to correct in it?
No, not that I know of.
Counselor, is there any reason why this gentleman should not be sentenced today?
No, Your Honor.
Upon plea of guilty possession of controlled substance, first degree meth, the defendant shall receive a sentence of 3 years probated for 5 years. He said do gainful employment, drug 30 or do 30 hours public community service. The contraband shall be disposed of. What is this court cost? $215. Pay that $30 a month starting 30 days after his release. He's to be probated. When do you want him to come to probation and parole office?
He married tomorrow morning, 9 a.m., Your Honor.
Judge, I think he has other holders.
Okay. Probation and parole will be up to see if you got other holders. They'll be up there on this case. And then what other areas do you have holders on? Here?
Clinton.
Where?
Clinton.
Clinton, okay. Well, we'll just get him ready for this one and you can take care of the one in Clinton. We have anything else we don't have anything else in Russell County, I don't believe.
No, Your Honor.
Okay, thank y'all very much.
Thank you.
Let's go to Southeast State Correctional Complex. Then we'll be to Adair County. Commonwealth versus Paul Bricker. Are you Paul Bricker?
Yes, sir.
22 CR 0084. Mr. Bricker, born in 1985. Last 4 digits, Social Security 1839. Is that correct?
Yes, sir.
What do you have here, Ms. Costello?
Your Honor, this was a case that we had set for mediation and we got very, very close, but didn't get it all the way resolved. So I believe you're gonna reset the trial date. Is that?
That's probably correct. I would like to get it past Christmas for the children's, excuse me, for the children's benefit if we could. Because you got 2 female children, juveniles, that'll be the primary witnesses in this case.
And Your Honor, we had filed prior to the mediation, a motion for bill of particulars where, I think that had kind of got put on hold because we were hoping the mediation.
Yeah, I actually forgot about it, so I need to answer it. If I could have 30 days to answer that, I don't know if you wanna, if maybe we should answer that and come back and get a trial date next month.
Yeah, and that's fine with me. I do want to advise the court, I have a murder trial starting on the January 22nd.
We're gonna miss you.
So I was just gonna ask for maybe not around that time after Christmas, but.
Well, if I could have till December, because the bill of particulars describe quite a bit of, I would say, intimate testimony concerning the children.
Yes.
If I could have till the Cumberland County motion day in December to answer that, and if we can't resolve the case, I'll get a trial date, if that's all right with the court.
December 21st.
Yeah.
Compile the bill of particulars. Okay. Okay, well, thank you very much. And thank you, Southeast State Correctional Complex, for your cooperation. Your attorney will be in contact with you, Mr. Bricker. Okay? Thank you very much.
Thank you.
Adair County Detention. Okay, we call Kenneth Alexander for arraignment. What? Commonwealth versus Kenneth Alexander, 23 CR 0097. Are you Kenneth Alexander?
Yes,
You were born in 1964.
yes,
Last
sir.
four digits of your social security number is 6237. You have a right to remain silent. Your attorney, Mr. Pendleton, is here. You're here for the purpose of arraignment. The grand jury of Cumberland County has charged you with assault in the second degree, wanton endangerment in the first degree. You understand what those charges are? I'm not asking whether you did or not. You understand what the charges are? Assault and wanton endangerment. You understand that? You understand what the charges are? I just read
Yes,
the
sir.
charges to you. You understand what they are?
Yes, sir. Yes, sir.
What's your name again?
What's your name?
Kenneth Alexander.
Do you understand the charges that I just read?
Yes, sir.
Okay. Do you acknowledge the identity of your client, waive formal reading and arraignment, acknowledge receipt of indictment, interpret not guilty, reserving all pretrial motions?
Yes, Your Honor.
Okay, we will have a negotiation date for the 15th and the next court appearance on the 21st. Have you had the opportunity to interview this individual?
I have not, Judge.
Well, I would suggest that you, from reaction here, I would suggest that you talk to him and see if we need any examination. Okay?
Yes, Your Honor.
Thank you very much. Thank you, Mr. Alexander. Your attorney will be up to see you, okay?
Yes, sir.
Timothy Alexander. Timothy Alexander. Commonwealth versus Timothy Alexander. 19 CR 0042 on pretrial diversion revocation and 23 CR 0039 on pretrial conference. Mr. Alexander, were you born in 1982?
Yes, sir.
Last four digits, social security number 5227.
Yes, sir.
What does the Commonwealth have to say in this case?
Your Honor, I think we need a trial date.
What is, come up to the podium so we can hear you. Okay, what is the charge in 42?
I think it's possession of controlled substance first and assault in the second.
Did y'all go to negotiation day on this?
We did, Your Honor. We didn't have all the medical records at that time. If you want to set us another negotiation day and then.
We have the records now.
Right. Yes, we've got them, but we didn't have them at the previous negotiation day. If you want to set a trial date in January, that work good for us.
Well, do you think further negotiation would help you, or do you want a trial date?
I think it would help, Your Honor.
Perfect.
Okay. Well, the next negotiation date will be December 15th. You come back here on December 21st, but if you see that you're not going to have any luck as far as negotiation, you can go ahead and start preparing for a January trial. We'll find a date to try
Yes, sir.
in January, okay?
Yes, Your Honor. Thank you.
Thank you very much. Crystal Ashcraft. Commonwealth versus Crystal Ashcraft. More, are you Crystal Ashcraft?
Yes.
Yeah, this is 23 CR 0069. Were you born in 1979, ma'am?
Yes, sir.
Last four digits, social security number 5007.
Yes.
Okay, we're here for a pretrial conference. What's the Commonwealth have to announce?
Your Honor, I think there's a case going on in Casey County. Is that right, Mr. Smith?
Actually, Your Honor, it's Adair County,
Adair
23 CR 123. Ms. Ashcraft has her next pretrial conference on November 28th. We hope, or she maybe expects to enter a plea there just to kind of see where we're at and maybe run that concurrent, run the time period.
So you want to have a negotiation date here on December 15th and the next court date on the 21st.
Yes, Your Honor.
That way you'll know about the Adair County case. You understand what they're saying, Ms. Ashcraft?
Yes, sir.
Okay, thank you very much. Both those are conditions of your bond. Kevin Beagle. Kevin Beagle. Commonwealth versus Kevin Beagle, 23 CR 0054. Are you Kevin Beagle?
Yes, sir.
Born in 1998? You what?
Yes, sir.
Okay. Last four digits, social security number 9401.
Yes, sir.
I'm here for sentencing. You're represented by Mr. Combs.
Yes, sir.
You had an opportunity to review this pre-sentence investigation report done by probation parole.
Yes, sir.
Okay, is it substantially correct, Mr. Combs?
Yes, it is, Your
Is
Honor.
there any reason this gentleman should not be sentenced today?
No, Your Honor.
Plead guilty of wanton endangerment, 5 counts. He shall receive a sentence of 5 years on each count to run concurrently for a total of 5 years. On operating a motor vehicle under the influence. Fourth offense, he shall receive 2.5 years. 5 and 2.5 years shall run consecutively for 7.5 years. Serve 180 days in jail with a balance probated for 5 years. Court cost, he shall enter the Cumberland County Specialty Court. Now, where is he along those lines? Where is the drug court?
I believe he was admitted this morning.
He was what?
He was voted in this morning.
Okay. So how far along is he to the 180 days?
Defense counsel had our copy of the PSI, so he didn't tell us.
PSI. Oh, Judge, PSI is downstairs. I had a fax this morning up to the jail.
You had what?
The PSI is downstairs. I'd have to go.
Well, I've got a PSI here. Had 165 days, 155 days as of the 9th. So he's getting right on.
Whenever the court wants to let Mr. Burton start.
Well, let's see. I'll let him out on when he gets signed up for his orientation. Okay, so they'll be up to see about your orientation, sir. And when you get oriented and they can get you in, we'll let you out of jail, okay?
Yes, sir.
What were the court costs in that? You got it there. Is it DUI? Have to be a fact. Did you put any fine on the DUI fourth?
No, there's none required. I'm aware of.
I know, but you can put one on it. Then say 600 what? 615 court costs. You start paying that $50 a month after you've been out for 30 days. Okay. You
Yes, sir.
understand? Okay, and then they'll do the orientation and let you out and start the drug court. I hope you can turn things around, man. Okay.
Your Honor, I was handed the DUI guilty plea form. May I sign the form on his behalf?
No,
Okay.
you have to get it up to him to sign.
I'll get it.
You realize when you plead guilty on the DUI thing that it can further enhance in the future because this is your fourth one. You understand? Okay. They'll be up to jail to get you signed the DUI form. I'll trust your attorney to turn it in to the court.
I will do so. I will do so today, Your Honor.
Thank you.
Thank you.
Christian Bowe. Christian Bowe. Commonwealth versus Christian Bowe, 23 CR 00102. Are you Christian Bowe?
Yes.
You born in 2004?
Yes.
Last four digits, social security number 4270.
Yeah.
Are you here for the purpose of arraignment? You have a right to remain silent. You're represented by counsel. The grand jury of Cumberland County has returned an indictment charging you wanton endangerment in first degree, fleeing or evading the police, speeding, reckless driving, disregarding failing to yield the right of way. You're represented by Mr. Cross. Mr. Cross, you acknowledge the identity of your client. Receive indictment, waive formal reading, and plead not guilty, reserve and all pre-trial motions.
Yes, Your Honor.
Schedule a negotiation day on the 15th. The next court appearance on the 21st.
Thank you, Your Honor.
Your attorney will be up to talk to you, Mr. Bowe. Derek Fox. Derek Fox. Commonwealth of Kentucky versus Derek Fox. Are you Derek Fox?
I am.
Were you born in 1976, sir?
Yes, sir.
Last four digits of social security number 5309. We're here in 23 CR 00123. You're representing the Office of Public Advocacy, Mr. Pennington, on a shock probation revocation. What has the Commonwealth to say concerning it?
Your Honor, if I may, what was that case number again?
21 CR 00123.
That different case number, but
Well, let's make sure that's what's on the docket. Y'all have any Mr. Case number?
Same thing you said.
all right, 22 CR 58.
I want the record to know that Mr. Pennington is finally wrong about something. 21 CR 00123. Okay. What's the Commonwealth have to say?
It's our motion, Your Honor, for, to revoke his, shock probation. And the allegation is, he had a new felony conviction in Indiana.
A new felony conviction in Indiana?
Yes.
You gotta stipulate to that. I guess he was sent back by Indiana.
Yes, Your Honor.
Supervision from up there.
Yes, he served, and we'll stipulate, Judge, he did serve his complete sentence in the state of Indiana.
Okay, well, you'll stipulate to that and revoke his shock probation and commence his sentence. Okay. Thank you very much. Todd Howard. Todd Howard. For Raymond. Commonwealth versus Todd Howard. 23 CR 0099. You're here for the purpose of arraignment. Mr. Howard, were you born in 1985? You born in 1985?
Yes, sir.
Okay. Last four digits, social security number 9931. Is that correct?
Yeah.
Okay. We're here today for the purpose of arraignment. The grand jury of, you have a right to remain silent. You're represented by the Office of Public Advocacy here. The grand jury of Cumberland County has returned an indictment charging you possession of controlled substance in the first degree, methamphetamine, possession of drug paraphernalia, possession of marijuana, operating a motor vehicle under the influence, careless driving, inadequate silencer on your muffler. Mr. Bailiff, do you acknowledge the identity of your client, counselor?
Yes, Your Honor.
Receipt of the indictment, waive
Yes, Judge.
formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions.
Yes, Your Honor.
Want to set a negotiation date in this case for the 15th. And on the 21st is the next court appearance.
Judge, if I could be heard briefly from Mr. Howard on bond.
Speak up a little bit.
If I could be heard briefly on Mr. Howard's bond, it looks like it was converted from a surety to cash on 11/12. We were just asked to be assured.
What's the deal on his bond?
Yes, Your Honor. Let me see what I can.
Where's this gentleman live?
Judge, I believe he's a Burkesville resident.
I'm showing. So,
What are you showing?
I'm showing, Your Honor, that, like she said, that Mammoth Cave's address, that he is coming back as a high 9, as far as.
Why is that?
And then a high 7 for FTAs. It looks like, Your Honor. Was, given points for, as far as he had a pending case.
What kind of pending case
and
was it?
also has,
What kind of pending case was it?
It's 23 F57.
What kind of case was it?
It's an penalty, and then the other reasons were.
What kind of case was it?
Okay. Careless driving, possession of marijuana, possession of drug paraphernalia, and possession of methamphetamine.
Okay, is he still out on that? You know, plea on it or what?
It's an F case, so.
F case. Pending cases there. And what about the FTAs?
Yes, sir. He. State also, Your Honor. It looks like that he had some older FTAs through Indiana and then a newer FTA for Park County in January of 22.
Well, you'll need to negotiate with the Commonwealth unless you want to bond. I'll let you schedule.
Yes, Your Honor.
Okay. Jeffrey Krager is next, is that correct? Is that correct? Commonwealth versus Jeffrey Krager. This is 23 CR 0086. Are you Jeffrey Krager?
Yes, sir.
Born in 1987.
Yes, sir.
Last 4 digits social security number 1263.
Yes, sir.
We're here on the pretrial conference. Y'all have a plea on this case?
That's correct, Judge.
Is that felony or diversion?
Felony plea, Judge.
Sir, a motion has been filed that says you wish to enter a guilty plea today. Is that correct?
Yes.
Are you currently under the influence of drugs or alcohol?
No.
Is this plea freely and voluntarily given?
Yes, sir.
Are you the same person named in 23 CR 0086?
Yes, sir.
Is your judgment impaired in any way today?
No, sir.
You understand the charges against you, and if you had plenty of time to go over that with your attorney?
Yes, sir.
Are you satisfied with his advice?
Yes, sir.
Now, I'm going to go over your rights under the Kentucky United States Constitution. And when I finish, I'm going to ask if you understand those rights, okay?
Yes, sir.
You have the right not to testify against yourself. No one can make the same thing. The right to speed trial by jury, the right to be represented by counsel at jury trial, the right to confront and cross-examine all witnesses called to testify against you, the right to produce evidence, the right to call witnesses in your favor, the right to appeal this matter to higher court if you lose, and the right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of charges against you by entering a guilty plea. That you give up all those rights. You understand that?
Yes, sir.
I may consider the Commonwealth's recommendation that I may apply any range of sentence allowed by law. I do not have to accept a recommendation. Prior to accepting the recommendation, I'll wait for pre-sentence investigation or probation for until I do not accept the recommendation and decide to impose a harsher punishment. I will reject the plea agreement. You'll have the right to withdraw your plea and have a trial by jury. What is the Commonwealth's recommendation, Mr. Judge?
The Commonwealth agrees to dismiss without prejudice fleeing or evading the police second degree on foot, resisting arrest, reckless driving, speeding 26 miles per hour over KRS violation, and the PFO second degree. And then upon plea of guilty to fleeing or evading police first degree, the defendant shall receive a sentence of 3.5 years. Upon plea of guilty to wanton endangerment first degree, the defendant shall receive a sentence of 4 years. Upon a plea of guilty of operating a motor vehicle with alcohol concentration of or above 0.08 or while under the influence of alcohol or other substance, the defendant shall pay a fine of $200. The two sentences to run consecutively for a total of 7.5 years to serve that the Commonwealth will oppose probation. Defendants have no contact with the victim. The defendant shall pay fine at discretion of the court.
Is that what you agreed to, sir?
Yes, sir.
Are you entering this plea because you did commit the acts that in the amended indictment?
Yes, sir.
Now, I've previously explained your constitutional rights to you. Knowing those rights, so explain it, still your desire to allow the court to fix your punishment. You
Yes, sir.
understand that after this, any future convictions could be enhanced as far as your penalty. You understand that?
Yes, sir.
You got the original here with his signature on it.
You have it, Judge.
Sir, is that your signature on there?
Yes, sir.
Okay. Well, I'll accept the plea order pre-sentence investigation report to be done by probation and parole. Schedule your sentencing on December the 21st. Okay, thank you very much. Thang Luke. Commonwealth versus Thang Luke. 23 CR 0041. Excuse me. Are you Thang Lu? You were born in 1987?
Yes, sir.
Last four digits, social security number 1263. We're here today.
I'm sorry.
23 CR 0041. We're here today for sentencing. Mr. Poindexter, you represent this individual?
I do, Your Honor.
Sir, have you had an opportunity to look at pre-sentence investigation report? Excuse me, by probation and parole?
Yes, sir.
Okay, is it substantially correct, Mr. Poindexter?
Yes, sir. The only thing that Mr. Lou pointed out to me is that it's got appointed counsel instead of me as being the attorney.
Did you note that he was private counsel?
Otherwise, everything else is correct.
Okay, on a plea of guilty to trafficking, the defendant shall receive a sentence of 5 years. Possession of a firearm, a convicted felon, 5 years. 2 years, 5 years shall run concurrently for 5 years to serve. Defendant shall receive credit for time served. What is the court cost?
$215.
Court costs $215. You can pay it starting 30 days after your release at $30 a month.
Sure, that's all I have. Excuse me.
Yes.
Thank you.
Thank you, sir. Kenneth Neal. Kenneth Neal. Commonwealth versus Kenneth Neal, 23 CR 0025. Are you Kenneth Neal?
Yes, sir.
Born in 1978. Last four digits is social security number 4427. You're here on a pretrial conference in 23 CR 0025.
Yes.
What's the Commonwealth have to say?
Your Honor, just been told he's got another case in Bourbon County. Is that correct?
That is correct. Judge, similar to Ms. Ashcraft, Mr. Neal has a case out of Bourbon, 23 CR 131. It's my understanding that he should be transported the next court date to enter into one of the rocket docket pleas. So Judge, if we could just get another date in hopes of running.
When is he going to be transported? When is he going to be transported?
Judge, I don't have the date on that Bourbon date in front of me, but it is 23 CR 1.
Have him back here on December 21st.
Yes, Your
Do
Honor.
you need a negotiation day in case he does that, or are you just gonna go ahead?
Please, Judge, yes, 15.
December 15th for negotiation. They're going to let you try to get up your other charge up north taken care of, and then he'll come back and meet with you, okay?
Thank you, Your Honor.
Okay. Raymond Oliver. Raymond Oliver.
No.
Commonwealth versus Raymond Oliver. 22 CR 00108. Are you Raymond Oliver?
Yes, I am.
1969.
Yes.
Last four digits, social security number 1975. This is a pre-trial conference. What does the Commonwealth have?
Your Honor, at this time, I don't think we have all the information. We don't have any laboratory reports.
Still waiting on DNA and the cell phone, report, Your Honor.
What report?
The cell phone.
Cell phone, yeah.
Yeah.
Well, you think you'll have it in December?
Did we get an update? I think we were gonna check and see how close they were.
You said it from negotiation day in December, pre-trial, we'll have some information from this hospital.
Negotiation day for December 15th, next court date for 21st. Mr. Alba, evidently there is some scientific or discovery information that your attorney needs that has not been finished yet. She'll be able to explain it to you. We have a negotiation date set for December 15th and your next court date for the 21st to enter a plea or to set a trial. And because you've been there a while, I'll make sure you get a quicker trial, okay?
Yep.
Okay, thank you very much. Robert Purdue. Kentucky versus Robert Purdue. 22 CR 0046. Are you Robert Purdue?
Yes, Your Honor.
You were born in 1963.
Yes, Your Honor.
Last four digits, social security number 3514. You're represented by Mr. David Cross. You're here for the purpose of sentencing. Have you seen the pre-sentence investigation report done by probation and parole? Is it, Mr. Cross, is it substantially correct?
Your Honor, I never received one. If it's,
Well, we just put sentencing off to next month.
well, I'd like to go ahead and put a moment to look at it.
No, you can't, he's up in jail.
Robert, did they send it to you?
Have you looked at that? I thought he said, yeah, have you looked at this pre-sentence investigation report done by probation and parole?
No, sir.
Just put off sentencing till December 21st. Jesse Randolph.
He said he's.
Carmel versus Jesse Randolph. Mr. Purdue? Mr. Purdue, let me explain. Have Mr. Purdue sit down. I'll explain to him what just happened.
Purdue. Christie, send him back. We've yelled at him, Your Honor. He has trouble hearing, so.
Okay, well, that's what I tell Mr. Purdue, that his attorney hadn't gone over the pre-sentence investigation report. He'll bring it up there and go over it with him, and we'll sentence him at the next rule day, okay?
Okay, all right, thank you.
Okay, thank you. Jesse Randolph. Make a note on Mr. Purdue's record that the next time he comes up, we need to transport him because of his hearing problem to make sure he can hear. It didn't prejudice him today, but it could in the future. Jesse Randolph, are you Jesse Randolph?
Yes, sir.
23 CR 0087. Mr. Randolph, were you born in 1981?
Yes, sir.
Four digits social security number 2641.
Sir.
We're on a pretrial conference. What do you have?
We have a resolution, Your Honor.
You have a felony plea?
Yes, Your Honor.
Swear it there. A motion's been tendered, Mr. Randolph, that says you wish to enter a guilty plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is the plea freely and voluntarily given? Are you the same person named in 23 CR 0087. Mr. Randolph, you the same person named there?
Yes, sir.
Have you had plenty of time to discuss this matter with your attorney, and are you satisfied with his advice?
Sir.
You know, you don't have to enter a guilty plea today. You have certain rights under Kentucky and the United States Constitution. Before I can accept a plea in this case, I need to know that you understand your rights. You have a right not to testify against yourself. No one can make you say anything. The right to speed trial by jury, the right to be represented by a counsel at your jury trial, the right to confront and cross-examine all witnesses called to testify against you, the right to produce evidence, the right to call witnesses on your behalf and have process issued to compel their attendance. You have a right to appeal this matter to higher court if you lose, the right to require the Commonwealth to prove beyond a reason without your guilty charges against you. Understand by entering a guilty plea today, you give up all those rights. You understand that?
Yes, sir.
I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. I don't have to accept the recommendation. Prior to determining whether I'll accept the regulation, I'll have a pre-sentence investigation report done by probation and parole. In the event that I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea and go to a jury trial. You understand that? What is the Commonwealth's recommendation?
Upon a plea of guilty to fleeing or evading the police first degree, 2 counts, the defendant shall receive a sentence of 3 1/2 years on each charge to run concurrently for a total of 3 1/2 years. Upon a plea of guilty to wanton endangerment first degree, 2 counts, the defendant shall receive a sentence of 4 years on each charge to run concurrently for a total of 4 years. The 2 sentences are to run consecutively for a total of 7 1/2 years. Serve 180 days. Balance shall be probated for 5 years. Probation is to be supervised. Defendant shall receive credit for 87 days as of November the 16th of 2023 and shall serve the remaining 53 days on home incarceration. On a plea of guilty to operating a motor vehicle with alcohol concentration of or above 0.08 or while under the influence of alcohol or other substances first offense, the defendant shall pay a fine of $200. Upon a plea of guilty to failure to maintain insurance on a motor vehicle, the defendant shall pay a fine of $500 plus court costs. On a plea of guilty to operating a motor vehicle with alcohol concentration of or above 0.08 or while under the influence of alcohol or other substances first offense, the defendant shall pay a fine of $200. Defendant agrees to pay restitution in the amount of $2,135, $1,000 to Burkesville City Sewer Plant, and $1,135 to EMK at a rate of $200 per month payable through the Cumberland Circuit Court Clerk's Office. First payment being due within 30 days of the entry of this plea and due on the first day of each month thereafter until paid in full. The defendant shall pay fines and court costs at the discretion of the court. The defendant shall remain on active supervision until any and all fines, restitution, and court costs are paid in full or until further request of probation and parole.
Is that what you agreed to, sir?
Yes, sir.
Accept this plea and order pre-sentence investigation report to be done by probation and parole. Have you back here for sentencing on the 21st of December.
And Your Honor, just for the record, I wanted to note, as the plea indicated, Mr. Randolph will be serving the balance on home incarceration. He does have employment with Lacrosse Enclosures in Albany, Kentucky. So we just wanted to get that on the record and see if he would be eligible to set his home incarceration up with Mr. Smith today.
If y'all have any objection, go ahead and start the home incarceration.
No, he got a Wayne County holder, 2,500 cash. Your Honor. He
Okay,
does
he's
have
got
a
the
holder
Wayne
for
County
Wayne
hold.
County.
They're telling us that he's got a Wayne County hold.
Okay.
So we'll go ahead and authorize him to set up the ankle bracelet on us, and then Wayne County you have to take care of that separately, sir. We can't do anything about that. Okay.
I'll be able to talk to you, Jesse.
And the ankle bracelet would be work, church, doctor, that sort of thing. Okay.
Yes, Your
Honor. Donovan Waller. Donovan Waller.
He's at the Class D facility.
I'm right here.
Okay.
Oh.
Did you say Donovan Waller is there?
He's at the Class D facility, Your Honor.
Okay. Now you have, let's say we have one other person.
He's on, Judge.
Okay. Donovan Waller, can you hear me now?
Yes, sir.
Okay, this is 23 CR 0090 Commonwealth versus Donovan Waller. Mr. Waller, you born in 1994.
Yes,
You
sir.
have the last four digits, social security number 3617.
Yes, sir.
Okay, we have a pretrial conference here.
And Judge, Mr. Waller is now serving state time. I didn't realize he was a state inmate, so we're close to a deal. I think if we could get one more negotiation date. we'll
Let's
have a
get a
resolution.
negotiation date on December 15th. Next court appearance, December 21st. Your attorney will be up and see you, Mr. Waller, see if they can probably do a deal to roll some of this time together, okay?
Donovan, I'll talk to you again.
All right. Thank you.
Okay, now let's go back to Adair County. I believe that we have Mr. Dallas Hayes up there. Dallas Hayes. Are you Dallas Hayes?
What is wrong with it?
Are you Dallas Hayes?
Mute.
It keeps muting.
I can hear y'all a little bit now. Mr. Harvey, are you involved in this case?
I am, Your Honor.
Do what?
I am, Your Honor. He was assigned to my caseload through probation and parole in Adair County.
Okay. This is Commonwealth versus Dallas Hayes, 23 CR 0066. Now, this was a situation here, I believe, where Mr. Hayes did not show up for sentencing. Is that correct? Is that right?
Well, Judge, today was a sentencing that he did not stay at rehabilitation. It's
Now, is that gonna determine whether the Commonwealth's gonna continue to agree to impose this sentence he agreed to?
You hear it now? You can hear it.
Honestly, don't know. That information I had that he just left rehab on the run.
It's not doing anything in here.
We have,
He was just served last night. He was just picked up. last
Right.
night.
I got that thing on the other second.
Well, I'm looking at the offer here. It says 3 years probated for 5 years. And said he shall enroll and complete the Crown rehabilitation in Springfield and receive no credit for time served. Yeah, and then he left up there. So I'm not really willing to probate. So I'm gonna sentence him to 3 years.
be fine.
Thank you very much.
Your Honor, that was my only case. Might be excused.
Absolutely. Court costs,
Thank you, Your Honor.
that last case, Mr. Hayes, how much? $215. He can pay it starting $30 a month after he's released. Now, Adair County, do you have anybody else for us up there?
But no, he was the last one.
Okay, thank you very much.
you.
Barron County is gone. And Russell, Southwest, everybody's gone. Is there anybody online that's at Corrections Institute that has anybody else for us? Do we have anybody else here? Who else do we have here?
We're ready on Maria Rivera.
Oh, she needed, use your interpreter here.
Lopez.
Okay, Maria Riviera. She was transported here.
Yes, from
Maria Riviera, Monroe County case. What about John Richardson? Who is his attorney? Where's he coming from, Mr. Pennington? Cincinnati or?
Judge, he actually started today out in far western Kentucky, so.
Well, he's not losing any time coming over this way then. So.
No, you're right.
Commonwealth Kentucky versus Maria Riviera, 22 CR 00160. Now we have an interpreter online. Will you turn your camera on, interpreter? Will you raise your right hand, please? You solemnly swear or affirm that you are qualified to be an interpreter in the courts of justice in the Commonwealth of Kentucky, to be received as a qualified interpreter before. Is that true?
Your Honor, yes.
Okay, thank you. Commonwealth versus Maria Riviera.
Estamos aquí en el caso de Fiscalía de Kentucky contra María Rivera, 22CR 00160.
Over the headphones. Are you Maria Riviera?
¿Es usted María Rivera? Sí.
You're here in,
Yes.
here in 22CR 00106.
¿Usted está aquí para el caso 22CR 00106? Sí.
You have a social security.
Yes. ¿Tiene usted número de seguro social? No.
Okay, you're here on a pretrial
No.
trial. You have an agreement?
Your Honor.
Judge, we do in principle. Now, I've talked to Ms. Rivera about it's a probated deal with a large amount of restitution. And what I anticipated is that she would be released today, but I spoke to Commonwealth and they didn't specifically agree to that. We didn't specifically negotiate.
I don't know what you're talking about now. You have an agreement?
We have a plea, Your Honor. We're ready for her to enter a plea.
Okay.
But I think her willingness to enter this, I think is possibly contingent on whether she'll be agreed to be released prior to sentencing on a probated.
Well, then we'll set her a jury trial then.
Tenemos un acuerdo. Bueno, nosotros habíamos llegado a un acuerdo con la fiscalía. Supuestamente nos habían dicho que ella iba a poder salir de la cárcel el mismo día de hoy y por eso ella se ha acordado en declararse culpable. Pero hoy la fiscal está diciendo que no se sabe si ella va a salir el día de hoy. Dice el juez, entonces, ¿tienen un acuerdo o no? Dice la fiscal, tenemos una declaración de culpable, sí. Dice el abogado, bueno, el hecho de que ella ha estado de acuerdo en firmar esa declaración de culpable fue a base de que le dijeron que iba a salir el día de hoy. Dice el juez, bueno, entonces podemos fijar una fecha para un juicio.
We have no objection to her being released.
I'm not
before-
gonna release
Okay, that's-
Tell me, what's the charge you?
It's receiving stolen property and there's a large restitution amount. That's the only reason why we wouldn't object is for her to start paying it.
Nosotros no nos oponemos a que la ponen en libertad el día de hoy. ¿Cuál es la declaración de culpable? ¿Ante cuál cargo? El de recibir cosas robadas y hay que pagar una gran cantidad de indemnización y por eso nosotros estaríamos de acuerdo en que la dejaran salir el día de hoy para que ella empezara a hacer sus pagos.
I don't remember saying that, but what about an ankle bracelet?
No entiendo. ¿Qué tal un tobillero electrónico?
I think she'd be agreeable to that. I mean, I know that costs money and she really needs to be putting all the money she can afford.
Well, my problem is.
Yo creo que ella estaría de acuerdo con eso, pero yo sé que un tobillero electrónico cuesta dinero y yo creo que todo el dinero que ella pudiera juntar se debería estar usando para pagar la indemnización.
I don't know all the normal things I would know in a PSI to make me determine those sort of things. I don't know any of that. I don't know whether she'd be subject to being easily supervised. I don't know any of that.
She has no previous criminal record, Your Honor.
Yeah.
Lo que pasa es que yo no sé ninguna de la información que yo normalmente sabría si recibiera el informe precondenatorio. Por ejemplo, yo no sé si sería fácil supervisarla, yo no sé sus antecedentes, yo no sé nada de esa información. Bueno, señoría, ella no tiene expediente penal.
How much is an ankle bracelet now?
It's $150 that's coming. Oh,
This is a Monroe County case. She's a resident of Tompkinsville.
Yeah, that's what I know that.
Este caso es de Monroe y ella es residente de Tompkinsville, sí.
Well, I'll tell you what I'll do. I will go ahead and accept the plea. And if y'all can reach an agreement on an ankle bracelet, I'll agree to put her out on an ankle bracelet. If she doesn't want to do that, then we can have a trial.
Yo lo que puedo hacer es aceptar su declaración de culpable y ustedes que se pongan de acuerdo en cuanto a un tobillero electrónico. Si ella no quiere que le pongamos el tobillero electrónico, entonces mejor fijamos una fecha para un juicio. ¿Quiere aceptar lo del tobillero electrónico?
Sí, pero me lo podrían hoy mismo.
Yes. I can get it on today.
Okay. The motion has been tendered that says you wish to enter a guilty plea. Is that correct?
Se me ha dado un pedimento para hacer una declaración de culpable. ¿Es cierto que usted quiere hacerlo?
Are you currently under the influence of drugs or alcohol?
¿En este momento se encuentra usted bajo efectos de drogas o alcohol?
No.
Is this plea
No.
freely voluntarily entered?
¿Se está declarando culpable voluntariamente hoy?
Sí.
Are you the same
Yes.
person named in indictment number 22 CR 00106?
¿Es usted la misma persona nombrado en la acusación formal 2012 R001060?
Is your judgment
Yes.
impaired today? Is your judgment impaired today in any way?
¿Hay cualquier cosa que impide su capacidad de raciocinio este día?
No.
You
No.
understand the charges against you?
¿Entiende usted cuáles son los cargos que tiene en su contra?
Sí.
Have you discussed
Yes.
this with your attorney and are you satisfied with his advice?
¿Ha hablado usted acerca de esa declaración de culpable con su abogado y está satisfecho con su consejo como abogado?
Sí.
Yes.
Are you fully informed about your case?
¿Está cabalmente informado sobre su caso?
Sí.
You understand that you do
Yes.
not have to enter a guilty plea.
Usted entiende que usted no tiene que declararse culpable, ¿verdad?
Sí.
You have certain rights
Yes.
under the Kentucky and United States Constitution. I need to know that you understand those rights.
Usted tiene ciertos derechos constitucionales, tanto garantizado por la Constitución estadounidense como el estado de Kentucky. Yo necesito averiguar si usted entiende que tiene esos derechos.
You have the right not to testify against yourself. No one can make you say anything.
Usted tiene derecho de no dar testimonio contra sí mismo. Nadie le puede obligar a hacer ninguna declaración.
The right to speedy trial by jury.
Tiene derecho a un juicio sin demora por jurado.
The right to be represented by counsel at all in all actions in this case, all stages.
Tiene derecho a ser representado por un abogado en todas acciones, en este caso digo, en toda etapa del caso.
You have the right to confront and cross-examine all witnesses called to testify against you.
Tiene derecho de encararse con y contrainterrogar cualquier testigo que viene a dar testimonio en su contra.
You have the right to produce evidence.
Tiene derecho de presentar pruebas.
The right to call witnesses in your favor.
El derecho de presentar testigos para su defensa.
The right to appeal this matter to a higher court if you lose.
Y el derecho de apelar este asunto a un tribunal superior si usted pierde el juicio.
The right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of the charges.
Y también tiene derecho de obligar a la fiscalía a comprobar más allá de una duda razonable que usted es culpable de haber cometido el delito.
You understand by entering this plea, you give up all those rights.
¿Entiende usted el hecho de que si se declara culpable ahora estará renunciando a todos aquellos derechos constitucionales?
Sí, sí.
I may
Yes, I understand.
I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law.
¿Entiende usted que yo puedo considerar la recomendación de la fiscalía, pero también yo pudiera imponer cualquier pena que está dentro del ámbito prescrito por la ley?
Prior to accepting any recommendation, I will await the pre-sentence investigation report from probation and parole.
Antes de aceptar cualquier recomendación de la fiscalía, voy a esperar la preparación de un informe precondenatorio de parte de la agencia de probation and parole.
In the event that I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you will have a right to withdraw your plea and have a jury trial.
En caso de que yo no aceptara la recomendación del fiscal y yo pensara imponer una pena más severa, yo tendría que informarle a usted y darle la oportunidad de retirar su declaración de culpable si usted deseara.
You understand that?
¿Me explico? Yes.
What is the Commonwealth's offer?
¿Cuál es la oferta de la fiscalía?
On a plea of guilty to theft by unlawful taking or disposition of more than $1,000.
You gotta slow up so she can translate.
Not receiving stolen
Your
property.
Honor, it's fine. She can say the whole recommendation. Thank you.
Says, it should be receiving, but it says theft.
Go ahead and do the whole thing, she says.
Okay. Upon a plea of guilty to receiving stolen property of more than 1,000, the defendant shall receive a sentence of 5 years, probated for 5 years, supervised. The defendant shall pay restitution in the amount of $18,419 at a monthly rate of $200 payable to the Monroe Circuit Court.
La recomendación de la fiscalía a cambio de una declaración de culpable ante el cargo de recibir cosas robadas con un valor mayor a $1,000 será 5 años bajo probatoria por 5 años supervisado. También tiene que pagar indemnización en una cantidad de $18,419. Tiene que hacer pagos mensuales de $200 y estos pagos los tiene que entregar a la Corte de Circuito del Condado Monroe.
The funds shall be dispersed in accordance with the restitution order submitted with this plea.
Y este dinero estará entregado de acuerdo con la orden de indemnización que está adjunto a la declaración de culpable.
Restitution is subject to a 5% clerk's fee, and the monies paid to the circuit court clerk shall be applied to the restitution prior to any other fees imposed by the court.
El dinero que se paga de indemnización también tendrá un honorario adicional de 5% para el juzgado, pero cualquier dinero que se paga se tiene que pagar primero a la persona que recibirá la indemnización antes de aplicarlo para los honorarios del juzgado.
Supervision shall continue until restitution is paid in full.
Y será supervisado hasta que haya terminado de pagar toda la indemnización.
The defendant shall receive credit for time served, but shall not receive credit for contempt time. The defendant shall have no contact with the victims, victim's real property, or victim's immediate family.
La acusada recibirá crédito por el tiempo ya cumplido, pero no recibirá crédito por el tiempo cumplido debido al desacato de la orden judicial. La acusada no podrá tener ningún contacto con las víctimas, con la propiedad de las víctimas o con la familia inmediata de las víctimas.
The defendant agrees to have any and all evidence in the above styled case disposed of in accordance with the laws of the Commonwealth and the holding agency.
También consiente que cualquier prueba que esté confiscado en este momento como parte de este caso será desechado de acuerdo con las leyes del Estado y de acuerdo con las reglas de la agencia que tiene las pruebas.
Is that what you agreed to?
¿Está de acuerdo con todo eso, señora?
Are you
Yes.
Are you pleading guilty because you are guilty of committing the acts charged in the amended indictment?
Se declara culpable porque es culpable de los actos de los cuales se le acusa en la acusación formal.
Sí.
Knowing the rights of explained,
Yes.
knowing the rights of explained to you, is it still your desire to give up those rights, enter plea of guilty, and allow the court to fix your punishment?
Entendiendo los derechos constitucionales que yo acabo de explicarle, es su deseo renunciar los derechos constitucionales a fin de hacer una declaración de culpable y permitir que el juzgado le imponga su pena.
You understand that,
Yes.
you understand that after entering a plea of guilty, future convictions could be enhanced.
¿Entiende usted que después que uno se declara culpable ante un cargo, si en el futuro tiene otra condena, las penas serán aumentadas?
As to the range of penalties, that is.
O sea, me refiero a dentro del ámbito de las penas. Yes.
Is your signature on here?
¿Esa es su firma en el documento?
Sí.
Yes.
Okay, well, I'll accept the plea, order a pre-sentence investigation report to be done by probation parole. When's the next date in Monroe County? December the 14th will be the sentencing day.
Muy bien, acepto su declaración de culpable. Voy a hacer orden para que se haga una informe precondenatoria de parte de la agencia de Probation and Parole. ¿Y cuándo será la siguiente fecha en el condado Monroe? 14. Así que el día 14 de diciembre será la fecha para la imposición de su pena, ¿sí?
Now, counselor, in all probability, I'll take that ankle bracelet off of her that day after sentencing.
I've got a TPR trial scheduled for that same morning. It's gonna last all morning in Allen County.
We'll come in the afternoon then.
We've got a hearing in Redcap.
We'll get somebody to come in your place then. Get somebody to stand in for you. 'Cause we won't be over there for another month.
Can we do it in the afternoon and I could be allowed to appear by Zoom, Your Honor?
You plan on having I want an interpreter there with her on that date. This is good here, but I want, if the document's not gonna be translated, if she's got any, I want somebody to go over that stuff with her, and then she'll have to meet with probation and parole.
Your Honor, we're gonna have a Spanish PSI sent to the jail for her to fill out to complete.
Okay.
Your Honor, the interpreter is going to interpret what has been said. If you give me just a moment, please. Pregunta el señor licenciado si no podemos cambiar la fecha del 14 de diciembre porque tengo un compromiso en la mañana, tengo un juicio que va a tomar toda la mañana, dice el juez. Pues ven en la tarde. En la tarde tengo una audiencia en otro condado, en el condado Metcalf. Bueno, busca a alguien que sea su suplente porque si no lo hagamos, el 14 de diciembre tendríamos que esperar un mes más. ¿Me permite comparecerme por video el día 14 en la tarde? Bueno, si va a haber un intérprete, mira, lo que yo quiero es que haya un intérprete presente con ella ese día, porque si hay documentos que ella va a tener que entender lo que dicen, la intérprete va a tener que leer los documentos. Y también hay que preparar este informe precondenatorio antes y ella va a tener que repasarlo. Dice el señor de la agencia sobre el informe precondenatorio, vamos a mandar el papeleo a la cárcel para que se la entreguen a ella y los documentos están escritos en español. Ella puede llenar los formularios.
But would it be possible if we did it here on the 21st, on December 21st?
Pues sería posible que lo hiciéramos acá en este condado el día 21 de diciembre.
We do it here on the 21st.
Sin objeción, pues hagámoslo el día 21 aquí.
Okay. Thank you.
Muy bien.
9 o'clock.
Yeah.
¿Será a las 9 de la mañana? Sí.
And I'll sign the documents to let her out of jail as soon as she gets hooked up over there at the jail, okay?
Y tan pronto que le pongan el tobillero electrónico en la cárcel, yo voy a firmar los documentos para que la pongan en libertad, ¿sí?
¿Y es hoy salgo?
So that would be today that I will be released?
Sí.
Puede ser cualquier persona que ponga el comando, tiene que ser el oficial del condado de Tompkins.
¿Perdón?
Puede ser cualquier persona que te ponga el commander o tiene que ser especial el de Tompkins, que lo pone el sheriff.
Is it just anybody that can put the ankle monitor on my leg, or is it someone specific that has to do that?
I'll contact Ricky as we go back to Glasgow.
Yo me voy a comunicar con ella cuando ella regresa a Glasgow.
The jailer just said that he'll contact Ricky Richardson, who puts them on, and they'll make arrangements at the jail for you.
El carcelero dice que al regresar a la cárcel se va a comunicar con un señor que se llama Ricky Richardson y ellos harán los arreglos.
Okay. Okay, does anybody else have anything? Thank you. Does anybody else?
¿Alguien más tiene otra cosa? Your Honor, may the interpreter be excused?
I request that if she is released before she completes that pre-sentence investigation packet that we're sending up to the jail, that she report to the Barron County Probation Patrol Office to give it to them so we can complete that PSI.
Okay, when do you want her to report?
Immediately upon release.
Okay, what they're going to do is send a Spanish language form for her to fill out for her PSI. And she needs to turn that in to the
Barron
County Probation Pro Officer by noon tomorrow. Is that okay?
That's fine.
By noon tomorrow, okay? If she gets out today.
Le van a dar un papeleo en español que son preguntas para preparar el informe precondenatorio. Cuando la ponen en libertad, el agente quiere que usted se presente en la oficina en Glasgow de la agencia Probation and Parole. Lo tiene que hacer antes del 12 del mediodía mañana, si la ponen en libertad hoy. ¿Me explico?
Okay, thank you. Anybody, you have Mr. Cross?
Your Honor, we have a law-
interpreter may be excused.
We have a law student.
Thank you, Your Honor.
Morning, and he's about to leave. I'll just like to introduce
A
him.
law student. Where's he from?
University of Kentucky, Albany, Kentucky.
How far along are
It's my first semester.
you? Do what?
My first semester.
Well, you still have time to become a podiatrist. It's not too late to make a check, because I will tell you, as a lawyer, nobody will ever think that they paid you too little, and nobody will be completely satisfied with your work. So where did you go? Where did you go to undergraduate school?
Lefty Wilson.
Well, good luck to you. What's your name?
Jacob Brown.
Jacob.
You know Renee Brown?
Yeah.
If I'm on.
Is that right? Yeah, I do know her. She a nurse?
Yep.
Yeah, well, she was very kind to my mother during her final illness. She did a great job. Before she was a nurse practitioner. Okay. Glad to see you.
Nice meeting you.
Yeah. Talk to some of these other lawyers around here too. Just don't get dominated, Mr. Cross. Okay, who else has got anything?
Very, very briefly, Cody Appleby, he was not on the docket, but he should have been. There was an agreed order passing it. He was just asking for some relief from his ankle bracelet.
Well, you'll need to talk to Commonwealth about that. What, do you have anything?
There's a show cause docket that says just start an hour.
Okay, show cause docket here. What do y'all have?
Could we approach on an ex parte matter?
Pardon?
Could we approach on an ex parte?
Yes, you can. I've got a show cause docket that I have to go down through here. It's not very long, and I need about a 4-minute break here. So let's go off the record, and then I'll be out. But if you're here for the show cause docket, you're next, and I'll get you out, okay?
Amber, did you tell the rest? Oh, he did, yeah. Richards, he has
It's just something we can get to get forward.
Christy, you going downstairs?
Wait. I don't know if we got it. That was the coffee. You have the courage to try. You messed up, was I nice?
Just it was still a little strong. It was still a little strong, but it's.
I've got a special order in for the next.
Let's go back on the record, please. Show cause docket. Tamara McCoy. What's she supposed to be paying a month? She owes $759. Have her to pay $30 a month. Mitchell York.
Judge, if I may, I actually represent Mr. York, and there was a $25 payment made on his behalf yesterday. I know you said it's $100 per amount, but I called some others, baby mamas, I called everybody that could possibly make a payment for you. Been incarcerated since August.
On this?
On this.
Okay, I'll let him out, let him pay $25 a month.
Thank you, Judge.
Okay. James Hurst. James Hurst.
July, August, October, maybe. That's the last payment.
Okay. Issue a bench warrant, let him purge himself by paying another $100. We'll put him on the docket for the next month, okay, since he's made some payments. Richard Hawkins. You what?
He paid $15. We thought he was getting paid.
Issue a bench warrant for him and have him pay $50. Purge himself by paying $50. James Krieg. Bench warrant, purge himself paying $45. Okay, does anybody else have anything to come before the court? Commonwealth have anything?
Well, we've got one more plea, but we're waiting on the arrival of Mr. Roach, who says he's been coming here for the last 10 minutes. Yeah, it's Joseph Strokes I've been taking out. Joseph Strokes from the okay.
What's going on? Where you at?
Tell him to stop in Glasgow.
He says he's 4 minutes away.
Yeah.
All right, what's he say?
What about Strode? What do you have about Strode?
We had, that it was carried over to today, but we don't have any.
I think it's supposed to be final sentence.
I wasn't even open, so I received nothing on that, so I wasn't aware of it.
Let's take it up the road.
Okay, let's go off the record to wait for our errant attorney to come. There's no child support document.
Yes.
Wes, you want to turn your microphone on?
Okay.
Okay,
Sorry.
this is Caps versus Caps. You're the attorney for the defendant, is that correct?
That is correct.
Okay, and there's already been a judgment and it's down to trial for damages. Do you agree to that?
That is correct.
Okay. When do you want, how long do you think it'd take to set this?
I would say 1 day, Your Honor.
What kind of case is this?
It's an assault and battery.
Who assaulted whom?
The defendant assaulted Mady and Jonathan Capps, leading to her having a broken hip and criminal charges against the defendant, David Capps.
What happened to the criminal charges? Were they resolved?
Yes, sir.
Okay. What are the issue? I mean, have you done discovery on this, Mr. Stevens?
Very limited, Your Honor. Mr. Poindexter has sent me a large cardboard box of medical records.
And that's pretty much it, Your Honor. We've got a significant bills.
Do you have a spreadsheet on it?
No, sir.
Well, I would think that in order to, box of medical bills is relatively worthless in this.
No, medical records, Your Honor, of the treatment
Medical
and
records.
such.
Well, what about bills?
Well, we do have the bills. We don't have a spreadsheet of them, but we can prepare one for trial.
Well, I'd kind of like to see them. You know, has there been an attempt to settle the case?
We've sent demand, Your Honor, but we've had no mediation or anything.
What was the demand you sent?
$150,000.
You didn't get an immediate check in response to that.
No, sir.
No, Your Honor.
We've got medical bills of $120,000 with a Medicare lien of $27,000.
Well, Mr. Stevens, what do you want to do? You want some time to depose someone, or what do you want?
I believe if we could agree on a mediator, that might be our best path.
Yeah, we're not opposed to that, Your Honor. We're just trying to move the case.
Who would you suggest? Is Bobby Richardson be okay to mediate?
Now, Judge, Rich Alexander represented Mr. Capps in the criminal charges.
Do that then.
Bob Young in Bowling Green at Elpo does a lot of mediation.
What about Phil Patton?
I've got no opposition to him.
I'm fine with that as well, Your Honor.
Y'all sign and get an agreed order to enter into mediation, and then we can set it on the docket in December. That'll give you over a month and a week to see if you can get a mediation set up. And
Okay.
I would suggest that you organize the medical bills in some way so that the mediator can look at them and you don't have to go like through a box or anything.
Right.
And is there anything else you'd like on a spreadsheet, Mr. Stevens?
Not at this time. If there is, I'll send a letter to Mr. Poindexter.
Be great. Thank y'all very much.
Thank you, Judge.
Yeah. Okay, Wright versus Scott Wright. Hey, now, was there another case?
The 3 cases were combined by you, Your Honor, back in 21. There's a 16 case and then the 21 cases. When you now.
There's 2 children involved still?
2 children, Ava and Carter. Ava's 10, Carter's 5.
Okay.
And Judge, just as a point of order, I'll enter my appearance on behalf of this case for Scott Wright.
I've read the affidavits. I You didn't file a response, or you just now getting into it?
So I'm just now getting in the case. I have read the motion. I'm prepared to go forward and make an argument as to why time sharing should not be suspended.
Okay. How many witnesses do you have?
I have one, actually. I have
Who
three.
do you represent, Ms. Thomas?
I represent Connie and Gary.
Yeah.
As to Ava, and they're also the residential for Carter. That's your 2021 order. But they've had Ava since 16.
My client has custody of Carter. She's 5 years old. She's the youngest child.
He's living with,
He resides with the Whites and the 2 children.
okay. Well, let me go through the rest of this docket and then I'll have a hearing on this, okay?
Yes, Your Honor.
Thank you, Your Honor.
Vincent versus Mackey. Motion to withdraw. Attorney for the plaintiff.
Your Honor, Alec got here on behalf of Pete Tripp.
Hi, Judge. Scott Best, on behalf of the plaintiff, Jeremy Vincent. I assumed responsibility for the file.
Good afternoon, Your Honor. Megan Jordan on behalf of defendant Mackey. And we obviously have no objection to the motion to withdraw.
I think the motion to withdraw should name the attorney that's withdrawing it. So if who wants to withdraw?
Your Honor, it's Pete Tripp. We named Scott Best in the motion.
When I said, before the court is counsel's motion to withdraw, I have reviewed and the record being advised is order that counsel's motion to withdraw is hereby granted. Didn't mention anybody.
Do you want us to supplement that? But
I'd like to replace it and then give and say whether it's counsel for the plaintiff or the defendant, and give them 45 days to obtain counsel, something like that. Usually we do,
Well, Judge, this is Scott Best again. I actually subbed in earlier, Your Honor. I think this is just a housekeeping measure filed by Mr. Tripp's office.
If it is, just make sure you put his name in it to get out, and just say that you have previously entered appearance for the party. Just have that in there to make sure the record's clear as to who represents the party now, okay?
Oh, that'd be fine, Judge. We'll take care of it.
Okay, thank y'all very much.
Thank you, Judge. Have a good day.
Thank you, Your Honor.
Thank you, counsel.
Justin Scott versus Markia Scott. Is Ms. Parrish in here? Looks like it's her motion. Scott versus Scott, what do you have here?
Judge, I believe the parties are close to a resolution. If
Well,
we
that
could,
sounds good to me. I'll pass over it and I'll bring it back out.
thank you.
Adair County Child Support Docket.
Yes, Your Honor.
Turn your camera on.
Oh, I will try my best. I always have trouble when hold on just 1 second. There I am. Sorry.
We just have one case on your docket today.
Yes, Your Honor.
3 minutes.
We have Alan Sparks.
Okay, you have Dean versus Sparks, 12 CI 000224. What do you have to report on that?
Your Honor, we are here to report that Mr. Sparks,
He's present here. Say something, Mr. Sparks. So it'll key the mic so you get on.
Yes, sir.
Okay. Say something again.
Mr. Sparks currently owes $6,343.78. His monthly obligation is $210 on current support and $52.50 on the arrearage. The last payment we received was in July the 27th for $230. Mr. Sparks has been incarcerated and has been out since October the 11th. So he's been out a little bit over a month. We've not received any payments or gotten any kind of information about work or employment since he's been out. We're asking for an order to show cause for him to have $525 paid by January the 24th. And of course, if he got any employment, and if he needs help with employment, we have the workforce group that can help get him employment, and we'll be happy to help him with that.
Yes, sir, Mayor Steve.
Yes.
I'll agree with that, and I can do that by January. Also, I'd like to request a hearing, a show cause hearing. I filed a motion for contempt, and that date is.
Well, okay, you need to speak up a little bit.
I'm sorry, I filed a motion for contempt for KRS 509070, and that date is the 21st.
Tell me what you want contempt hearing on.
Show cause hearing.
For what? To show cause about what?
To get the visitation 2 days during the week and every other weekend.
This is just a child support docket.
Right. Okay.
That's
well,
all I have. You'll have to go somewhere else.
Right. Well, then the show cause of my issue is just having to pay the person who abducted my daughter child support 6 years ago, and I've been reporting to DOJ. I got them reports. I've got everything.
The only thing I've got here is this order here.
Okay.
To enforce. It's the last order that was in 12 CI 00224.
Right.
If you want to challenge this in any way, or if you want to talk about custody or those, it's not before me. This is just the county attorney's child support docket. Isn't that right, county attorney?
Yes, Your Honor.
If you want to open anything up, you'll have to get an attorney and do it in Adair County.
Yes, sir.
Okay. Okay.
And
I'll go ahead and sign the order then.
Thank you, Ms. Hutchinson.
Thank you very much. You have a great day.
Thanks, sir.
You got the order down here to me?
I'm sorry, Your Honor.
Order down here. Do you have an order for me to sign?
Yeah, we'll submit it to you if you don't have a copy. I've got a copy in my file.
Okay. Thank you so much. You have a great day.
Thank you. You too.
Okay.
Bye-bye.
Did you get a report, Mr. Cross, in the Burlington versus Burlington case?
I was able to reach Mr. Connolly, and we don't have an agreement in this case.
You don't have an agreement?
No, we don't. And we're here, and
I'm not going to enter. I mean, why does he say he wasn't here?
he didn't. If the court's reviewed the pleadings, he tendered a proposed temporary order. I told him yesterday we were not in agreement with it.
When is the next Clinton County rule day?
Judge, may I?
Let me ask you.
Okay.
Yeah, when is the next Clinton County rule day?
December 11th.
Okay, go ahead and say what you want to.
Your Honor, you set this today because we had it was the fault of my office. We sent him a motion out for November blank. And even though they were aware of it, technically they didn't get proper notice. That's why it was set for today.
Was he there when I said it previously?
You told me to renotice it.
No, I'm asking you, was
No,
he
he was
there?
not. He
You're
was
not
not.
asking to answer the questions I'm asking. I'm just trying to
No,
refresh.
he
Okay.
was not.
Get him on the line there.
We'll bring it up there, Your Honor.
Get him on, yeah, you bring it up here.
Mr. Connolly, it's Judge Williams here.
Yeah, Mr. Connolly, this is David Williams. How are you today? Just fine. How are you? I'm blessed. Thank you. What are you going to do with this Burlington versus Burlington case as far as Mr. Cross wants a hearing on it, and evidently you can't reach an agreement, the two of you can, which is perfectly all right. Do you have testimony you wish to offer at some juncture?
Well, Judge, my client is under doctor's order. She can't travel more than 30 minutes away from her home. That's one problem. So if we have a hearing on it, we'll need to do it by Zoom or some fashion.
I have no problem with that. I have no problem with her appearing by Zoom.
Now, the other thing is, we ought to be able to settle this. I don't see what the problem is. We're talking about a very temporary situation just until the final hearing on it. My client's concerned about the safety of the children, and I know Mr. Cross doesn't agree with that. But we've offered to allow his parents to come and get the children every other weekend and basically supervise the visitation. And we're talking about maybe 2 or 3 or 4 weekends, who knows, until we can get this ready to go. Although she is pregnant and will.
Well, is it scheduled in front of my commissioner?
You said it for, you told us to set it for today in front of you.
Well, so it's set in front of me today for the hearing.
Yes, Your Honor.
Yeah.
And he's not here.
Well, that's Judge, it was set for temporary motions. Mr. Cross called me last night after I'd left. I didn't get the message till this morning. And it sounded like from the message I got that we were pretty close to settling it. I frankly had come to work this morning dressed to go to court and intended to go. But based upon that and the telephone call to Mr. Cross's office, I decided that it probably wouldn't be of any benefit to go. And I apologize to the court for not appearing. It certainly wasn't my intention.
How far off, Mr. Cross, are you on agreeing on something temporary?
Your Honor, there's an issue regarding whether or not any supervision might be warranted. Our position is there's no need for it. We're prepared to offer testimony in that regard. Children are in no danger. He lives with his parents. There's no danger at all. And that's the main issue. We wanted to try to get some holiday visitation in place, but we're content with the every other weekend on a temporary basis.
Well, I would certainly advise her to agree to the holiday visitation as far as that goes. We just want to make sure the kids are safe. And we think that
here's the thing about it, rather than bring up any harsh feelings over making any allegations that you don't know for sure about, let's see if you can do let's do some every other weekend visitation with the parents and then some holiday visitation and see if y'all can work this whole thing out. And then we can limit it to what we have the hearing before. And I might put you in front of the commissioner so you can get in front of my family relations commissioner, domestic relations commissioner, before you get back in front of me if you can't settle it. Okay. Okay. So will you get a hold of your client immediately and see what kind of Thanksgiving and Christmas are we talking about so we can set it out here?
Okay. And every other weekend.
Yeah. With his parents, since
visitation will be with his parents, right?
Well, there'll be him and his parents. He'll be there, and then his parents because he lives with his parents. Okay. Okay, and then his parents will transport the child back and forth since your client seems to have some kind of health problems temporarily.
That's fine, Judge. We'll agree to that readily.
Your Honor, we also, I realize that the mother has the health issue, but we felt like driving from Albany to Winchester, Kentucky was a whole lot.
I thought they were there in Winchester.
Winchester, and we think there ought to be some sort.
How about meeting at
Renfro Valley?
At Renfro Valley be a fair place to meet. Renfro Valley.
Renfro Valley?
Yeah. You don't know where Renfro Valley is?
Oh yeah, I know.
Yeah. It's right up the road from Corbin. I know y'all don't acknowledge the existence of a bunch of those little bitty towns if you're from Corbin.
Yeah.
Okay, well and what about Christmas here? You need to find out when does your family do Christmas? On Christmas Eve or Christmas morning?
They usually is, sir.
Okay, well, I tell you what, she'll the one child involved, 2, how old are they?
4.
Okay, well, she'll have the days before Christmas, and have the child on Christmas Eve and meet down at Renfro Valley at 11 o'clock. That way, that on Christmas Day.
Okay.
That way Santa Claus can come before they get underway. Okay, you understand what I'm saying?
And how long might he keep it from?
Well, what day does Christmas fall on us? What day of the week?
It falls on a Monday.
Okay, well, you get Christmas Day and the next day. Okay,
Just make sure I understood that. Who's to pick up the child at 11 a.m.? Is it Mr. Cross's client?
They do Christmas on Christmas Eve.
okay, they say they do Christmas on Christmas Eve is what the mother says. When does your client's family do Christmas? Could you find that out? She from Albany? Well, she doesn't have, if she can't travel, then he can just bring the children back up there on Christmas Day and meet someone at Mount Vernon at 11 o'clock. So he'll have them on Christmas Eve since she can't travel. She won't be coming back down to Albany anyway. So he can have the day before, like the 23rd, get them on the 23rd and bring them back on Christmas Day, 11 o'clock at Mount Vernon. Okay?
That'll be fine, Your Honor. We'll agree.
And then what about Thanksgiving next week? What's the deal?
What do y'all have Thanksgiving?
Thanksgiving Day.
You do it on the day. Thanksgiving, they do it Thursday afternoon. So if we could get her Thursday morning and take her back the next day to get them, that'd be great.
It's on the weekend for the weekends. Get Thursday.
Thursday morning?
Yeah, have the child, they'll pick the child up at Mount Vernon at 11 o'clock on Thanksgiving Day.
Take her back the next day.
Take her back the next day, okay?
Right. Is that Mount Vernon or Renfro Valley?
It's a Renfro Valley exit, Mr.
Well, that's the same thing there, you know.
There's two Mount Vernon exits.
Yeah, the Renfro Valley.
Okay.
Okay, thank
That'll
you.
be fine, Your Honor. We'll do that.
Okay, if you'll get the order over to Mr. Cross and then I'll sign it and put it in the record tomorrow, okay? Thank you very much.
Thank you, Judge.
Yeah, thank you. Bye.
Timing on every other weekend.
Or they go to school?
Yeah, one's in preschool. Well, she's in preschool right at the second grade. So, yeah.
Well, they need to be like 5 o'clock on Friday. Give them time to get down there.
Make it all simple.
Yeah, they're an hour ahead of us.
Let's make it all
Way
simple.
back on Sunday.
Let's get them back home by 4 on Sunday so they can get ready for school.
So I have a
Work hard.
Do what?
Work hard.
It'll start next weekend?
What we want, well, next week's Thanksgiving. We wanted to start this weekend because he's not
I'm
seen
not
him in
gonna start
weeks.
this weekend. We need everybody to get adjusted. You're gonna get Thanksgiving. So let's start the week after that, okay? Okay, thank you. We have a DVO docket. Are the parties here for the DVO docket? Okay, that's Christy Nicole Lee. Are you here? Well, there's no service on it. Where does Jared Wayne Stewart live? See if you can get the sheriff to call up there himself. Talk to the sheriff up there, okay? That works sometimes, okay? Pass over that. Now we'll return to the case we have in front of us here. Okay, let's do Wright versus Scott Wright.
Judge, you wanted to use the table or podium, how would you?
Use the table and the witnesses will take the witness stand and
Yes, Your Honor.
y'all can come up here you probably want to sit next to your client while the cross-examination is going on, if you hadn't talked to her very much, you know.
Thank you, Judge.
Ms. White, would you like to make an opening statement?
Your Honor, I represent Justin Wright, and he is the petitioner in this case, and he's filed a motion to terminate and or suspend the visitation at this time with the mother, Kendra Scott Wright. At this time, it's Justin's position that the mother has not visited the children since maybe late February of this year, and that this order was entered 2 years ago, and during 2022, there was random visitation only.
Okay, I don't want, that's generally what you're about, right? Is there anything else that's for the other conduct that should influence my decision on suspending visitation?
Well, there was criminal charges, felony drug use during 2022. She is in rehab at this time, and it's our position that there be no visitation until maybe revisit it when she is released in February.
Now, Ms. Thomas, do you represent someone?
Yes, Your Honor. May I? It'd be easier to hear me, please.
You can do it right there if you want to.
Okay, thank you, Your Honor. Yes, Your Honor, I represent Connie and Gary White. They have been the primary custodial parents of Ava, who is now 10. They've had her since 2016. By your order.
They want to suspend visitation too.
They want to suspend all
for the
visits.
same reasons Ms. White says.
Yes, Your Honor.
Okay, thank you.
Yes, sir.
Now, do you have a response to that?
Yes, Your Honor. Judge, I think the key word is that they're looking to suspend time sharing while Ms. Wright is doing her best. She's in rehabilitation. She's going to be there to February. She's giving birth there. And in fact, the cabinet.
She have another baby now?
She does, Your Honor. And
where's that baby?
Actually with her. She's at a rehabilitation where she can actually care for the minor child. And she has a minor son that she's having Zoom multimedia visits with.
Another son besides these two?
That's correct, Judge. And
Who has that baby?
Excuse me?
Who
With the
has
father.
that child?
With the father, I believe, Your Honor.
Move over center there so I can hear you. No, right.
Oh, in the center. I believe the father, Your Honor.
Who is that father?
Justin Scott is actually in.
Yeah.
I think has a case on today, Judge.
Another child. Yeah. So two of the children, one of the children are with the Whites, one of the children with the biological father, and one of the children is another biological father, and she's got one in rehab.
Yes, Judge.
Okay, I just want to make sure we get this down right. Okay.
And Judge, it's our position that suspending time sharing now while she's doing her best is only going to further distance any contact or any goal of reunification that the court may have in mind, or as the cabinet is indicating in their a letter to the court discussing that in lieu of suspending time sharing, or excuse me, suspending visitation. Judge.
Okay, I got you. Let's call your first witness.
I'll call Justin Wright.
Okay, come up here and take a stand. Raise your right hand. You swear the testimony about to give us the truth, whole truth, and nothing but the truth. Take a seat there and lean forward into the microphone and state your name.
Is this the mic? Justin Allen Wright.
Okay.
You want me to stand
Yes,
here?
please.
You're Justin Wright,
Correct.
and where do you live, Justin?
I live at 1630 Leslie Road.
And who do you live with?
My sister Connie White.
And who all lives in that household?
There's quite a few of us. Me, my two daughters, Carter and Ava, Gary White, Connie White, Clifton Brown, CJ Brown. I think that's it.
Okay, those are two children that live there as well, besides your two children.
They've adopted, Connie and Gary adopted.
And do you all have adequate space for you and your children in that home?
Oh, yeah.
Do the children have their own private areas and private bedrooms?
Yes, they do.
And let me talk to you about the children a little bit. How old is Ava?
Ava's 10.
And how old is Carter?
Carter's 5.
And you have custody of Carter, the youngest.
I
that's
do.
5. And when Carter was born with drug addiction,
Yeah, her mother was under the influence when
and
she
that
was
was
born,
5 years ago.
5 years ago.
And since that time, has there been,
Objection, Your Honor. At this point, the motion is regard to suspending visitation. We're getting into things more than 5 years ago. The court's order has only been in place for 2 years.
Let's go right to suspending.
okay,
Thank you, Your Honor.
there was a court order entered in the fall of, I think, September of 2021. Is that correct?
That's
In which
correct.
you received custody of Carter?
Yes,
And your sister Connie and her husband Gary received, because they had previously had de facto custody of Ava. Is that correct?
that's correct.
And since that time, what was the visitation given to, I'll just say Kendra, Miss Kendra Scott Wright,
That's with Carter.
with the children? Yes.
It was once a week visitation at DCBS offices here in Burkesville.
And who took the children to that visit?
Connie did.
Was there a reason you didn't?
Yeah, me and Kendra, I was a victim of assault and I couldn't go do it myself.
Okay, so your sister went and
Yes.
took the children. Do you know if that visit was consistent each week in
It was-
late 21 and 2022?
It was sporadic.
Objection, Your Honor. That's the lack of personal knowledge, as the witness just testified. He didn't take the children to the meeting, so he would not know how the meetings went.
And were you present when the children, prior to them going to the visit and after the visits?
Yes,
And did you observe their conduct prior to and after the visits?
I did.
Can you explain what you observed about their behavior?
A lot of times when they came back from the visits, their mother would give them bad news, like she was being
Just what you have personal knowledge of what you see.
incarcerated, and they were heartbroken. You know, it really hurt them.
Okay, and when is the last time, to your knowledge, has Kendra exercised any contact or visits with Ava and Carter?
I'm thinking it's February of this year.
Okay, and since then, has there been any efforts that you're aware of?
She's been incarcerated ever since.
Okay, and do you feel that it's in the children's best interest to continue with any type of visitation at this time?
Not at this time.
And do you feel that, well, let me ask you this question. The children have an older brother.
Yes.
Is his name Drew?
Yes, Drew Scott.
And how old is Drew?
Drew, 14.
And you're not the father of Drew?
No.
And did the children continue to have contact with their brother Drew?
Yeah, he came for Carter or Ava's birthday party here recently.
So he's welcome at Gary and Connie's and
Anytime.
visits
Anytime.
occasionally? And are the children bonded and connected with him?
Oh, yes, very much so.
And are the children bonded in the home the occupants of the home that you reside in?
Yes, yes, very happy.
What is it that you're requesting the court to do as far as reviewing this case at some point? You said you didn't feel that any visitation was appropriate at this time.
Well, until she gets out of rehab and proves that she's stable, and then revisit then.
Okay, and have you been advised of when that she's going to be released?
I'm not sure. I'm not sure the date.
That's all I have with this witness at this time.
I have no questions of Mr. Wright, Your Honor.
Yes, Your Honor. So, Mr. Wright, I wrote this down, one of the last things you said, that you want visits suspended until Kendra's stable, right?
That's right, sir.
You know she's at rehab right now, right?
Yeah, this is her second go at rehab. She got expelled from the previous rehab she was in. So,
She's at rehab right now?
yeah.
Typically, when people are at rehab, they're stable, right?
You could say so.
Okay. So she's stable right now?
I'm not aware of her situation right now. I just know she's in rehab.
Okay, so again, you wanted to revisit this. So you're not saying she doesn't deserve any time.
As of now, I do.
Just right now, she doesn't
Right
deserve
now,
time.
yeah.
Right now, when it's holidays?
No, I
Right
didn't
now,
say
when it's
that at all.
Thanksgiving,
As of this time, she's in rehab. I think it should be postponed until she's out.
after the holidays,
Well, she's out of rehab.
after Christmas,
When she's out of
So-
rehab.
after the holidays. Okay, and this one time a week. These are video visits, right?
Yes.
Like Zoom, like the court right now.
Are you talking, are you talking
The
previous,
visits that Kendra's having with the girls.
the previous visits?
Yes.
It was in person at the DCBS office under
Okay.
supervision.
But let me clarify. DCBS has offered to accommodate Zoom visits, right?
I'm not aware of that.
Okay, so you're not aware of what DCBS has recommended for your daughter?
No.
You were talking about actually, you don't have no further questions this time.
Just a couple of follow-ups. Mr. Wright, you said it was like February or late February last time that Miss Kendra visited the children.
Yes.
So that's went on 9 or 10 months ago. Is that correct? And there's been no contact in between?
That's correct.
Do you feel that a few more months is going to make any difference? Or
Well, is that including Zoom meetings and stuff? Well, I mean, or is she just talking about since she's physically visiting?
I'll clarify that if you wish. Do you feel that any?
I'm not interested in what he feels. I want you to tell me about what kind of visitations that she's had, if she had Zoom contact or anything else.
Okay.
Ask him a question so he can talk.
Has Miss Kendra had any visits, Zoom or otherwise, since February of 2023?
No.
And prior to that, how were those visits conducted and where?
They were at the DCBS office, supervised visitations down there.
And who attended? You stated your sister?
My sister would take them down there and then DCBS done the supervision on it.
And are the children is their behavior good now?
Oh, they're doing great.
Consistent?
Yes, very well.
That's all I had.
If I may, Your Honor. Mr. Wright, may I ask, if I understood you correctly, you said the visits that she was to have were in person at the DCBS office. Is that correct?
That's correct.
Have you been advised since February of this year by DCBS office as to whether they want to continue those visits?
They do not. They want to move them. They want to send them to a counselor is what they want to do.
So you're saying DCBS no longer wants to participate in those visits?
They wanted to close the case.
Okay. And when you say close the case, is there an active case?
I'm not aware of.
Okay. So if I understood you correctly, they wanted to cease the visits at DCBS?
Yes, correct.
All right. Thank you, sir.
Mr. Wright, have you reviewed the letter from Ms. Renee dated 11/16/23?
I have not.
Okay, so you don't know what the cabinet is actually recommended to do.
I've met with the cabinet when they wanted to close the case. That was the last time I
When was
actually,
that?
in July, I think.
They told you they wanted to close the case in July?
Yes.
What was this about referring it to council? Said something about council.
Well, they just wanted to stop doing the supervised visits there since they were done with the case. So they wanted to find somewhere else to do it, do the counseling, or it was really counseling. It was just somewhere else to do the supervised visitations.
Okay, so they didn't want to stop visits, they just wanted to change the location.
Yes, they were done with the case.
Okay. So they weren't saying Kendra doesn't need to have any more visits. That's not what the cabinet was telling you.
They just wanted to be there.
No further questions, Your Honor.
Okay, call your next witness.
That's the only witness I'm going to call, otherwise it would be repetitive.
Do what?
That's the only witness I'm calling in my case.
Ms. Thomas, do you have anything?
Yes, Your Honor. I call Connie White, please.
That's right. You come up, take a stand up there. Raise your right hand. You swear or affirm this one that gives the truth, the truth. Take a seat, lean toward the microphone. State your full name.
My name is Connie Wright White.
Miss Connie, where do you live, please?
1630 Leslie Road.
And who lives with you?
I live with my husband Gary, my brother Justin, and then Carter and Ava, and then our two adopted boys, CJ and Clifton.
All right. And you had this motion brought before the court to cease visitation with the biological mother, Kendra Scott Wright. Please explain to the court why.
I wanted to stop the visits because I think it should be in the child's best interest, it shouldn't be about Kendra. It should be about the girls. The girls are doing great. They're doing great in school. They're making grades. I mean, Ava just joined Beta. She is perfect. She's making great grades, and Carter the same. They're happy little girls. They have friends. They get to visit with their brother. They're going to church. They're happy girls. Whenever they did have visits back in the beginning of the year, they would get very upset. Some of the things that mommy would say, mommy's having a baby, mommy's got to go to jail. It would upset those babies so much. They're stable now. They're happy. They're doing great.
Miss White, to your knowledge, when was the last time, and it's been identified, you took the girls down there. When was the last time you took the girls down there for a visit?
The best I remember, it was February or March. It was the earlier part of 2023.
This year?
Yes.
Since that time, through DCBS or directly to you, have you received any cards, notes, letters, drawings, anything from Kendra addressed to the girls?
No, ma'am.
When are the girls' birthdays, please?
April is for Carter, and then October is Ava.
Did you receive any cards, birthday cards, greetings, or anything for the girls on their birthdays?
No, no, ma'am.
May I ask, please, during 2022, the order went in November as identified to the court in 21. During 22, how many visits did you take the girls down there to visit with Kendra at DCBS?
It wasn't a lot. I mean, it wasn't every time that they were supposed to visit with her, because sometimes she was incarcerated. Sometimes she would just call in sick or, call in for another reason. She didn't visit regular.
Okay. And the order of the order of June of 21, as recited in November of 21, granted her how many visits?
That was one per week.
Okay.
One per week. Mm-hmm.
All right. And have you had a meeting with DCBS as identified by Mr. Wright concerning DCBS continued providing services to Kendra Scott Wright?
We did meet in September. And at that meeting, it was Justin and Gary and I, and Miss Renee and Miss Kayla Strunk. And they recommended.
Okay, that's hearsay. So
okay. Those are the parties that were there.
Yes.
Judge, I actually had I'm actually interested in what Ms. Renee has to say. So.
Okay, go ahead then. We'll ignore the rules of evidence.
And Kayla Strunk is what position at DCBS?
She is the supervisor at that office.
Okay. And you've identified Renee Tooley as being what?
She visits us. She's our worker.
The ongoing worker.
Okay. Yeah, she visits us monthly.
All right. And you were advised of what for the cabinet to continue to do or not do?
Well, the best I remember, it was that they were wanting to discontinue those visits because it had been so long, that they had been in the system for so long. And they were going to refer us to counseling and let the visits be conducted during counseling instead of meeting at DCBS, because it was my understanding DCBS doesn't get reimbursed when there's not an open case, and they were wanting to close the case.
Okay. When you refer to an open case, Was it just simply the court ordered supervised visits, or was there an ongoing case as defined under dependency neglect?
Excuse me,
It was the
Objection, ma'am, objection. At this point, I'm gonna object to.
Too late, you could let them open the door and sit down there. I'm gonna let them talk for a while, but not long.
Please go ahead and finish your answer.
Okay, what did you say? He distracted me.
When you refer to a case,
Right.
was that simply the supervised visits?
Yes, the supervised visits is what we were there for.
Got it.
Yes, ma'am.
And you have attached an affidavit to the motion to cease visits. May I show that to you at this point? I'm sorry.
I've read it.
Oh, okay. And you affirm all the statements contained therein. Is that correct?
Yes, ma'am.
All right. Thank you.
White, you have anything you'd
I
like
have
to ask?
a couple of questions. Connie, you stated that the visits from November 2021, when the order was entered, up until February of this year, the visits were sporadic. Is that what you stated?
Right.
Has there been an occasion when Kendra called and stated she's moving out of state?
Yes, ma'am.
And do you recall when that was?
I don't remember the exact date, but she met that day with the children and told them that she was going to be gone. Mommy was going to be gone for up to 3 weeks, but she would be back.
She said that in front of the children? Mm-hmm. Did she state where she was moving?
The best I remember, it was out west.
Did she state at any time she was moving to New York?
Yeah, she did it at one time to New York also.
So she's had 2 encounters with you in front of the children?
Yes.
And on each of those occasions, did she make the comments in front of the children?
Yes, she did.
What was
the kids meant? She told the kids.
She told them in front of you?
She did.
And what all did she tell them about the New York move?
But that Mommy had found a new job and that she was going to work and she was going to be gone for a while.
And then was it a long time before she said she's moving out west, or was it close in proximity?
I think there was some time span between the two.
And these would have been in 2022?
Right.
These conversations?
Right. Mm-hmm.
Did she actually, after she made these statements about moving, did she actually miss a few visits after that?
She did. She did.
And did she contact the children in any fashion while she's missing these visits?
No.
Are these Zoom visits that you're talking about now?
No, we're talking about the in-person visits in 2022.
Yeah.
Okay.
In person.
Do you feel that it is in the children's best interest that there be any type of visitation and interaction with their mother at this time?
Not at this time. I feel like that once she completes her rehab and is better and can talk with her kids and the kids not get it, I think that, it's just not a good idea right now. It should be the kids' best interest, not Kendra's. And I know how upset the children got, when they met with her. And it would take some time for them to get back stable.
And you feel that they've adjusted since the end of February, 1st of March from not seeing their mom?
They're doing very well. And Miss Renee told the children their mom's in rehab, and they know that. They know that.
That's all I have. Thank you.
Ma'am, so again, just like your brother said, no visits
Come on up to the microphone.
at this time. You think it'd be appropriate in February, March, right?
I'm not sure when she completes her rehab, but I think it needs to be looked at again after she completes her rehab.
After the holidays.
Don't know when she's gonna complete.
And when you were talking about, so you were asked about your affidavit, right? I'm gonna cover a few things in it and just see. You had testified that, to your knowledge, the last contact Kendra had with the children was in February or March, right?
It was early this year.
Right.
Yes.
So in paragraph number, when you say, since the last visit, Kendra has not sent any cards, letters, notes, or attempted phone calls or social media through the DCBS office to the custodian.
Turn around here, you're speaking to me.
Until after the birth of her latest baby in October 23 when she wanted to introduce the girls to their youngest half sibling. You wrote that, or that's your word, right? So Kendra has been trying to reach out to the girls.
Where I can hear you.
So Kendra has been trying to reach out to the girls.
After those dates.
So that wasn't true when you said that about February, March.
I'm not sure what you're saying.
And then you said that she would, well, the time she would miss was when she was incarcerated, right?
She was incarcerated from March up until she was in rehab when she had her baby.
So she can't have in-person visits if she's in jail, can she? Yes or no?
I wouldn't think so. no,
Okay.
sir.
If she's sick, she's ill. You said sometimes she would say she's sick and not come for visits. You wouldn't want those little girls to get sick, would you?
No, it was several times, yeah.
But you don't want to get sick, do you?
No, sir.
And you mentioned trips. So if Kendra's telling the children, hey, I'm going somewhere for a few weeks, that explains why she's not coming to the next visit, right?
But it was very upsetting to the little girls.
Because they weren't going to get see their mommy the next week like they were used to, right? Right?
I have no comment, sir.
No further questions, Your Honor.
Y'all have any redirect?
May I show Miss White her affidavit to ask specifically about the paragraph Mr. Pennington referred to? Thank you, Your Honor.
Step behind the microphone and read the paragraph.
Ms. Conant, the paragraph reads, since the last visit this year, said Kendra Scott Wright has not sent any cards, letters, notes, or attempted phone calls or social media contact through the DCBS offices to the custodians, that's you and Mr. White and Justin, until after the birth of her latest baby in October of 2023, when she wanted to introduce the girls to their youngest half sibling. That's your paragraph.
Yes, ma'am.
So from February, March, April, May, June, July, August, September, October, Kendra Scott Wright attempted no contact concerning Ava or Carter. Is that correct to your knowledge?
To my knowledge, yes, ma'am.
Thank you. Thank you.
Okay, do you have anything else?
No, not this witness.
Okay, do you have any other witnesses?
Yes. I'd like to call Kendra Scott Wright.
You can take a seat down, man. You raise your right hand, please. Swear to testimony that is true.
I do.
Take a seat there, lean forward. Full name.
Kendra Scott, right?
And where do you currently reside?
And 41 Cribs Hill in Grayson, Kentucky.
What is the name of the facility, please?
A Mother's Journey.
All right. Are you there voluntarily or involuntarily by court order?
It's hard to answer that question. I believe, I think it's by court order. I wanted to go on my own. I agreed to go. I was asked by probation and parole if I would want to go, and I filled out the paperwork and told them, yes, I would like to go. So they helped me to file that paperwork and to go.
Can you leave the facility anytime you want to?
No.
No. When is the anticipated date of your discharge?
February or maybe March, maybe pushed off because the holidays. It just kind of slows things down with us getting our step work done.
And that is of
2024.
Okay. So in November of 2021, the court here adopted Commissioner Sohn's recommendation of September 21, giving full custody of Carter to Justin. Is that not true?
Yes.
Okay. And since 2016, Gary and Connie have been de facto custodians and primary care provider for Ava. Is that not true?
Yes.
During any of these periods of time, if you contribute any financial support whatsoever to these children?
Objection, Your Honor. Again, we're here about
Yeah, just keep. on
visitation,
moving,
not,
keep on
not
moving. All right,
support.
sustains.
Withdraw. Okay. The last time you remember visiting with Ava and Carter at DCBS office this year was when?
In April, right after Ava's birthday,
Right after Ava's
or
birthday?
Carter's birthday, sorry. Ava
Carter's
just had a
birthday.
birthday.
Okay. Did you have an incident that happened in Barron County around that time?
I did.
And what was it?
I was arrested for shoplifting.
And what were you shoplifting?
Toy for Ava and Carter.
Carter came into protection with Justin in May of 21. Is that correct?
Yes.
And by court orders in June of 21, following a hearing, you were granted 1 hour a week supervised visits with the girls at the DCBS offices. Is that correct?
Yes.
And have you attended every one of those?
Except when I was incarcerated or in the rehab facility.
And you are swearing under oath that you attended every other session except when you were incarcerated or at a rehab. Is that correct?
I'm quite certain that I have. I don't ever recall calling in and saying that I'm sick, I can't be there, without rescheduling when we had to move it to the next day. But I've never missed a visit. There's been visits that I didn't get to see them because Connie didn't bring them, but I showed up.
And you said that you didn't make a visit because you were incarcerated.
Correct.
During that 2-year period, a 1.5 year period, how many months were you incarcerated?
Lord, I'd really have to think about that. Let's see. In 2022, is that where we're starting? I was incarcerated from June. I was incarcerated for 87 days. And then I spent 10 days and 2 days and then 40 days. That's up till the most recent, which was I was released to Independence House in July of this year.
When did you go into Independence House?
Isn't that, I believe that's correct. Sorry, my date's a little mixed up. I went from jail directly to the Independence House. And I was there for 72 days.
Why were you discharged from Independence House?
I believe it was because I was trying to self-induce labor is what they were saying.
And how did you do that?
I'm not sure. I was 9 months and I had the green light, in my doctor's words, to go ahead and have the baby. I was 37.5 weeks pregnant and I was walking. There's nothing that I could have done medically, as in like taken anything. So I'm not sure. They had a kickball match to help me to go ahead and go in labor.
So you're saying in July, you were 9 months pregnant with your youngest daughter.
Okay, let's move on here.
Well, this is important.
That was 72 days after I went in.
And the baby wasn't born until October.
She was born September the 9th. I was 44 days.
Let me ask you this. Is there some reason why you didn't send any birthday cards, notes, letters, correspondence, drawings, anything?
I did to
who?
DCBS.
So it's your testimony, and Renee, you're saying Renee Tooley's going to back you up on that?
I would think. So I was Kaylin's drunk.
Would it not be in the children's best interest to wait and let you try to get stable
No, I
and
would-
rehab
I would
versus?
disagree with that. I love my children and I'm very, very good with my children. And I apologize if it upset them, but my children have more of a right to know where I'm at than anyone else. And I've never lied to them. But I'm a really good mom. And Connie and Gary have always told me that. Even they believe that.
So how many criminal charges during this really good mom period of November of 21 until today have you racked up?
I couldn't answer that. It's quite a few.
More
Small-
than 10?
Yes. It's hard.
And you
when-
made the choice
Let her
to,
finish her answer.
okay.
It's hard when you're told you can't see your kids. It's really, really hard. And yes, I understand that I have had a drug and alcohol problem. Alcohol is my drug of choice, and it makes me quite crazy. But I just missed my kids, and I've tried so hard since 2016 to just get to be a part of their lives. And every time I come to court, I get less. And I try so hard. And I understand that, yes, I catch charges. I go out there and I do some stupid stuff. But I just miss my kids. I don't have any other things to do when you're on drugs and alcohol. You're not thinking clearly. But I'm clean now. And I'm doing really good. Really good. I'm proud of me. I have to say, if I may, I am doing really, really good. I love this program. I would recommend it to anyone. It is a really good program, and I have really good therapists and staff members, and I work in these steps, and I put my all into it. I'm sorry for crying, but I want this so bad, and I'm so proud of where I'm at today. And I just want to see my kids. I
If it
love
were
them so
determined to be in the
much.
children's best interest not to have contact with you at this time, wouldn't you rather put your children's needs above your wishes?
I, without a doubt, feel that my children are happy and that they are being taken care of. And I have never said a bad word about Connie, Gary, or Justin Wright for not taking care of my children. I know that they're happy, and I'm so proud of that. But I don't think that it is in their best interest to keep them from their mother. If you spoke to DCBS, you would know that my visits with them go wonderfully. I've been told time and time again that I am the best mother that they have ever seen come through there because of how I interact with my children. I bring them crafts every visit. I bring them snacks every visit. I bring them gifts every visit. I sit down on the floor with them. I don't play on my phone. I don't do anything. I am there with them, and we have a great time every time. I just want to be with my kids. Telling me that I can't be with my children is what made me drink so much. It's what made me use. And I'm not proud of that, but I'm not trying to take back the past. I just want to be a part of their lives. I would never try to take them away from what they know so well. And I'm so glad they're doing great. That puts a smile on my face. I have no doubt. But my children love me and they respect me so much. They act so well when they're with me. Like Drew's 13, 14 years old, and he's 14, but he was 13 when he went to live with his dad. And I've never had a problem out of that child. I've never had a problem out of Ava or Carter. They're amazing. My children are amazing. And a lot of that has to do with the fact that I am a really good mother.
Doesn't it have more of the fact of where the children have resided? Ava since 16, Carter since 21. Isn't that the defining factor?
I understand why you think that, but all my kids are super smart, and Drew's never lived with them. He's very well behaved. He's never lived with them. They act better, and from what I've noticed, when they're with me in that 1 hour than they do when they want something and when they're with them. They're unruly. And I'm not saying that it's anything against their parenting. I'm just saying it's a respect thing. They have a lot of respect for me in the way that I speak to them. And since they were really small, they walked early, they talked early. You know, they've always made good grades. You can't say that it's all on them. I've had as much of a hand in it as I possibly could, as I've been able to give. So yes.
So this continued visit is for you and not necessarily the best interest of the girls.
I disagree with that.
I think that's all the questions, Your Honor.
I just have a couple.
Okay.
It's right. It's not right. You said that wrong. You stated that alcohol was primarily the problem that you've had in the last couple of years. Is that correct?
Yes.
But you have had a charge in Metcalfe County of possession of controlled substance. Is that
I
correct?
did, yes.
So there has been drug involvement and drug use.
There has, yes.
Since we were in court in November of 2021.
Yes.
And during those times, you spent, was that the occasion when you spent 72 days in jail? Was that in 2022 or this year?
I'm sorry. I spent 72 days in the rehab.
Okay. How many days do you think you were in jail in 2022?
I was in there for 87.
87. And then this year, did you serve any time in jail or just rehab?
Yes, I was in jail this year for 52 altogether in separate times.
So about 130 days you've served since 2022 and 2023 that you've been in jail, and then you've been in rehab an additional 70.
I was in there for 72 in the Independence House, and I have been at A Mother's Journey for about around 65 days.
So you've missed quite a lot of the visits since 2021. Is that correct? And that's due to your own conduct and your own criminal charges. Is that correct?
Yes.
That's all I have.
Give me redirect.
Briefly, Your Honor. Kendra, are you having FaceTime or Zoom visits with your son right now?
I am.
How are those going?
They're going great.
We've been here for a while, and why is it in the girl's best interest to continue speaking with you, or just start speaking with you?
Why is it in their best interest? Because they have the right to know their mother. They deserve to have a relationship with their brother that they don't get to see. And I'm a good mom. They love me.
Andrew, you mentioned times that you showed up at the cabinet. They did.
Correct.
How often did that happen?
Several.
The cards and that. Have you sent cards, letters, notes, messages?
I have.
It's already been testified. She already testified.
No, those are all the questions I have.
You have another witness. You may stand down.
I call Connie Renee Tooley with DCBS, please.
Swear to swear or affirm that testimony about you is the truth and the truth.
Yes, sir.
Have a seat there, lean toward the microphone, and identify yourself and with whom you're employed.
My name is Connie Renee Tooley, and I work for DCBS, Department of Community-Based Services.
Ms. Tooley, how long have you been with the cabinet, please?
A year and a half.
Okay. And are you the assigned worker dealing with the supervised visits of Kendra Scott Wright with the two minor children, Ava Wright and Carter Wright?
Yes.
And if you would explain to the court how those visits were conducted.
They were supervised by the CBS office. The visits would go well. I have no reason to say that they didn't go well. She did interact with her children. As far as how the children acted afterwards, I cannot attest to that. But during the visits went well.
Okay. And did you, as a staff, DCBS, physically see the visits during the supervised visits?
Yes.
Okay. I direct the court's attention to the filing of June the 9th, 2023. Ms. Renee, there is a report that you filed consistent with the judge's order dated May the 12th, 2023. Do you have that report with you?
No, I only have the one I filed.
Okay, we'll talk about that in just a moment. May I show a copy of the report to Ms. Tooley?
What is the report?
You will find it filed on June the 9th.
What is the report?
It is the update status report as to whether or not Ms. Kendra Scott Wright complied with the visits and the drug screening as ordered by this court.
No, just answer the
Okay.
question. I'm not gonna we're not liking it.
Yes, sir. All right. May I ask you, during the period of 2022 and until you filed this report in 23, did Kendra Scott Wright submit herself to random drug tests as ordered by this court?
No, she did not.
Did she attend all of the visitation schedule that she had granted to her?
They were sporadic,
Okay.
due to her being incarcerated. And then she would show up at times, but then, there wouldn't be a visit. I'm not sure, it's been a while, and I'm not gonna sit here and say that I can remember every visit, because I can't.
All right, and then I believe you filed a supplemental report with this court dated May the 16th, 2023. Is that correct?
Yes.
Okay, and I direct the court's attention to that document also, Your Honor. May I ask you, you've heard testimony here today under oath that you, DCBS, Representative DCBS, received writings, notes, cards, and gifts submitted by Kendra Scott Wright for the girls. Do you have those in your possession?
No, I do not. I did not receive anything from Kendra.
That's what I thought. And to the best of your knowledge, how many visits did Kendra Scott Wright have this year with her girls?
To be honest, I can't remember. She went from January to February. They were sporadic. At the most, I'd say maybe 6 or 7 visits at the most. Like I said, they were sporadic due to her being incarcerated.
All right. And in your November 16, 23 report, what was the reason you were advised she was discharged from the Independence House in Corbin?
She was there from June 8th to August the 14th, and they told us that she was medically discharged due to inducing herself into labor.
She attempted to induce herself?
Yes, ma'am.
All right. And to your knowledge, when was the latest baby born?
To be honest, I'm not real sure the date of her birth. I just received message that she had the baby. I called the rehab that she is currently in and spoke with her then, and that's when I found out.
Okay.
So I don't know the actual birthday.
And from looking at your notes, it seems as though the first contact she made wanting to have a Zoom visit with Ava and Carter was in October of this year. Is that correct?
Yes, ma'am.
All right. Thank you, ma'am. Your Honor? You stated that the only visits she missed was while Kendra missed was because she was incarcerated. Do you know that on each of those visits that she was incarcerated?
Yes, ma'am. I kept a check on the jail website.
And were there possibly other visits that she missed when she wasn't incarcerated?
There may have been that I didn't supervise because I didn't supervise all of them. We took turns supervising. So if she missed one and I didn't catch it, it was because I wasn't there.
So you wasn't the supervisor for all of them?
No, I was not.
That's all I have.
Like you inquire?
Yes, Your Honor. Is it Miss Tooley?
Yes.
Okay, I just want to make sure, I don't want to call you, so Miss Tooley. First thing you said when you took the stand and started testifying a moment ago was that the visits were going well from your perspective, right?
Yes.
that you didn't know how the children would react after the visit. You could just attest to that hour.
Right.
And the visits that Kendra didn't attend, you said that usually, to your knowledge, those were excused, if you would, by her being in jail.
Yes, I did.
Going to your report dated today, in the first paragraph, last two sentences, you state there have been no visits with the girls and their mother. Zoom video calls have been offered to the guardians of the girls, but they have declined at this time. Could you tell us a little more about that?
I mean, it's verbatim. I offered that when Kendra asked for visits with the girls, I mentioned it to the guardians. Well, I actually mentioned it to Connie. I hadn't talked to Justin, and I told her that Kendra would like to do visits with the girls. And I was told at this time they just didn't feel comfortable because of her being in rehab, and they would rather her be out of rehab to do the visits instead of her in rehab.
Can you put some dates or any more context to when these conversations may have occurred?
No, I cannot put the dates. I'm sorry.
Was there more than one attempt from you to try to initiate Zoom contact?
I mentioned it a couple of times, yes. You know, we have to do it per policy. So, I mean, I mentioned it, and that's when we were told that, you know, to talk to her lawyer, and she was going to talk to her lawyer about it and get back with me.
Now, you talk about during a regional consult done during 6/28/23.
Yes.
June 28th, it was discussed that the cabinet was to work on a permanency goal due to the case being open for an extensive amount of time.
What that means, the regional consult is with the head of DCBS. They wanted us to find an alternate way of having the visit supervised due to we don't have an actual case open, but we have to do the supervised visits. And where there is no actual case and we're just doing supervision, we have to open a case in order to do supervision there.
Is that from your concern? Is that problematic?
I don't have a concern doing anything, but you know, we have to do what we're told, and it's per policy that the case has to be open.
So when we heard testimony earlier that you had came and said the cabinet wants to stop the visits, that wasn't completely true, was it?
It's not stopping the visits, it's just finding an alternate location for the visits.
You go on and you say, at the time of the discussion with the custodians, they advised that they wished for no contact between the mother and the children. If the family had agreed at that time for family therapy, the cabinet would have asked permission from the courts to be released from supervision. Again, that was an inquiry you made to the petitioners.
Yes.
And they said no, correct?
They would have to talk to their lawyer and get back with me. Because they felt that it would be better if, you know, Kendra was out of rehab in order to see the girls in person than to see her on Zoom.
Given your experience as a social worker, when you have more time and distance between contact, does that pose problems?
It depends on the case.
Now, you say at this time the cabinet is still working with each family member, have monthly contact to monitor the case plan. And I guess again, you're saying has made available visitation for the mother and children at the DCBS office. Again, that option has not been taken advantage of by the petitioners, right?
Right,
But it's available there at the cabinet.
yes,
You're available to supervise those Zoom calls.
yes. I was actually I'm the one that supervised the Zoom calls with her and her son.
That are going well.
Yes.
Thank you, Your Honor. I have no further questions at this time.
I have two or three just to follow up on these questions, if that's okay. I don't understand, Ms. Tooley, what you were saying when you said, you had to, open up a case or change the location. If you change the
Well,
location,
we had offered doing a therapeutic setting for the supervised visits. We can't do we can do the supervision if there is a case open. But where there is no case, where this was brought down from the court, when they got de facto that we do the supervision because of I'm really not sure why they didn't want to do supervision themselves, because I wasn't here at that time and I can attest to that.
when you say open a case, does that mean you have to open a dependency abuse neglect action in the
Yes.
district court? And so
Yes.
you would have to go back and open up a court case in district court alleging one of those allegations?
Right, and we have no standings for that.
Okay. And when you say that you was gonna send them outside the counseling, or therapist or therapeutic setting, you wouldn't be actually supervising it. That would be a third-party contractor or?
Yes.
So it wouldn't actually be the cabinet supervising?
Right.
And as a social worker and a caseworker, have you seen many children where their parents skipped out on the visits frequently?
Yes, I have.
And in your opinion, in your capacity as a caseworker, do you feel that that's harmful to the child?
Well, it depends on the age of the children and the case at hand. Sometimes if, depending on the age, it may bother the child and then it may not. Every case is different.
Do you feel that irregular visits sometimes can be more harmful to a child than no visits?
Yes.
That's all I have.
Okay.
No, Your Honor.
Let me sit down.
That's my last word.
Do you have any witnesses at the?
Judge, I have no proof. Judge, I have no proof. I don't believe that the petitioners have carried
Well, I
forward
haven't
enough.
asked your argument yet. You don't get to.
No, Your Honor, no witnesses.
Y'all have no further proof to put up.
No.
Okay, now you come up and make your argument.
Yes, Your Honor. I believe at this time that the petitioners have failed to meet their burden, even under a clear and convincing standard, Judge. They have brought forth allegations that someone who is in rehabilitation, presumptively doing their best, is a danger to the minor children. And I think the telling testimony was that of Miss Tooley, saying there have been multiple requests made by Kendra to have Zoom contact. And it was the petitioners that took the job of the court to decide what was in the children's best interest. They sua sponte suspended visitation before the motion was even heard, Judge. And now we've got a mother who's just requesting 1 hour a week to talk to her 2 daughters. That's it. And they don't even want to give that.
Your Honor, I think that we could go back to the old saying that one has the key to the jailhouse, so to speak, or the key to freedom. And I think that applies when Kendra Scott Wright left this court in the November 2021 proceeding. She had the keys to establish a bond and stability and a change of lifestyle for her children. At that time, she has shown a continued unstable lifetime filled with criminal activity, drug use,
alcohol use, she stated, and neglect of her children. Just the fact that she's in jail does not excuse that. It's her behavior, not the children's behavior, no one else's fault that she had to miss those visits. And she seemed to approve of her conduct like that and wasn't concerned at that time. The priority wasn't visiting her children. And the children have got used to not having contact with her since February. And you've heard Ms. Tooley's.
I don't know that. You say that there's no evidence of that. They've gotten used to it. The children haven't been interviewed by any expert or anything. There's no testimony, child psychologist, you know. So, I mean, you can say that for argument purposes, but, you know, I don't know that.
Yes, I agree with you. There's been no expert testimony about that. But my position was that the children have had to adjust to not visiting their mother. Maybe that's a better phrase. And in hearing the testimony, they have adjusted. They're doing well. They're happy. They're bonded with their family members, even their brother, Drew, who's 14. And I just, in sake of argument, if Miss Scott Wright is released from rehab in February or March, it may be a repeat, as it has been. Carter was born with alcohol addiction or drug addiction 5 years ago. So it's just
no testimony here about that.
I think Mr. Wright testified to that. But
I don't remember talking about being born with alcohol.
I think I asked him that. But in any case, to get the children ramped back up with these visits, and then she gets out and goes back through the same spiel. There we are again. The children's mother disappeared, in jail, whatever. We would like for her to show some stability at some point, a pattern of it when she's on her own and can make her own choices. Right now, she doesn't have that privilege. She's confined in the rehab facility. So it's our position that it would be more detrimental to start up visits after 10 months, even if it's telephonic, video, whatever, and then abruptly change that in February.
Let me ask you something. Obviously, these are smart kids. They're doing well in school. They're smart kids. They're in a loving environment. They got an extended family, that sort of thing. Is it better for them? Who's talking to them about how their mom's doing it right now? Anybody telling them that your mom's doing a lot better? And we got hopes that you can reestablish a relationship with her. Sometimes she loves you. I hadn't heard any testimony like that, but I know these people. I mean, I've dealt with all these people ever since I've been on the bench on this thing here. And none of them ever really have very bad things to say about each other like I'm used to, except she is a drug addict. She's an alcoholic and a drug addict, and she's been a criminal, you know. But at some juncture, there needs to be, how would you suggest it ease back in? Let's say you want to wait till she does this. Now, if you wait for every person in prison or everybody that's addicted to have certainty, then you're going to be disappointed because recidivism rate is really high when you got drug addicts. Thank God you don't have a drug problem. Thank God I don't have a drug problem. I thought I knew a lot about drug problems until I became a circuit judge, and I found that I didn't know anything about drug problems because everybody that I ever dealt with had a support group like this behind them, a family behind them, you know. Then you get out and you get somebody that doesn't have a support group behind them, they're out there on their own, then they go into these sort of things. So I think you made some valid points, and I'm sure Ms. Thomas is too, about being careful about what sort of interaction, getting their hopes back up, being disappointed again, all those sort of things. But what do you think that there ought to be something going on here to kind of ease her back into their lives if they get better? You admit that if she gets better, recovers and goes out, that she ought to have some involvement. You haven't asked to terminate.
No, we haven't, Your Honor. I can just be frank with you and state what we had offered and what I've met with Ms. Thomas and the Whites and Mr. Wright, and we've even submitted this idea to Mr. Pennington that perhaps we do once a month a limited Zoom contact until she gets out. and see if she shows any pattern of stability for a period of time during screening.
Are the children seeing any therapists or anything now?
I really would have to defer
Yeah.
my client to ask that.
Well, I'm just asking because a lot of people know, I don't want to offend any therapists that are, but some people think sometimes therapists do more harm than good. Some people think that, and you know, some people want Christian therapists, people involved that have, share their faith and that sort of thing. I just didn't. Okay, you have anything else you want to share with me?
That's our argument.
Okay, Ms. Thomas, you want to say something?
Majority of the argument was presented by Ms. White. Your Honor, I do want to bring to your attention a couple of very salient points if you're considering the testimony of Ms. Scott Wright. She made the blanket statement and reiterated it twice that she had sent cards, notes, letters, and gifts to DCBS. DCBS has no dog in this fight. Under oath, DCBS
Well, Ms. Tooley said she didn't have them. That doesn't.
said she had nothing.
Well, she didn't have them. That doesn't mean nobody had them. I don't know. I don't know about that, but I've taken note of that.
Okay.
She said that Ms. Tooley has no reason not to be truthful. I watched her a little about a year and a half or so, maybe a year. I don't see her very frequently, but I've always found her to be truthful. I don't doubt that she doesn't have them. Why would she say she didn't have them if she doesn't have them?
Thank you, Your Honor.
Okay, go
I just
ahead.
wanted to bring that point to the court's attention. Your Honor, the choices that Ms. Kendra Scott Wright has made, those were her conscious choices. The bottom line here are two little girls, 1 5, 1 10. They're doing great, as they are right now. When Ms. Kendra Scott Wright completes rehab in February and is released, she can't be released till then, and is able to show and confirm to this court, Your Honor, that she's willing to live a clean, sober life, let's get a specialist, as you said, a therapist who specializes in reunification.
Okay, well, what about let's get one now? And what about let's get somebody to find
Judge,
out?
we're ready for
Well,
reunification.
I'll call on you in a minute. Okay. What's about let's get one now and get some expert advice after they interview everybody involved and get a reunification plan back to see whether what these folks here instinctively believe by knowing these kids and being with them all the time, more than you, more than me, more than counsel over here. Let's find out. Somebody give us some professional advice on what it's like. Yeah, I'll just you have something else.
That's the primary salient
Okay, well,
point, Your Honor.
here's this thing, and I don't want to be rude about this, is when you choose to procreate with someone and you have children with them, you know, you don't know what, you know, it's kind of like Forrest Gump used to say, it's like a box of chocolates. You know what I mean? Everything's good while you're courting and while you're wooing and while you're, you know, very intensely in love or in lust or whatever it is. And then problems develop. And, you know, one of them ends up being have an alcohol problem, drug problem, addiction. We talk about choices people make. I believe in choices. I made bad choices in my life. Most everybody I know has made some bad choices in their life. But I'm not so sure that just leaving these children just out there wondering whether their mother loves them or not. They're old enough to know that. Where is mom? She's in a rehab. Why didn't she contact me? Well, I don't know. We don't want to talk about that. I'm sure knowing these people, small community, I know all these people, and I've watched them go through this agony over these children and take good care of the children. You know, no doubt about it. I see the children out publicly. You know, they're well-behaved, happy children. And I've known the mom when she used to work in the restaurants here in town. I saw her around before she had her addiction problems, and they were that sort of thing. So I don't really know what to do here. It's my inclination to think that you hadn't met the burden to just completely cut communications off with her. I don't, but I'm not so sure what that burden ought to be. what I'd like to see is let's get together and see what some professional people think about this. And neither side has provided any of that at this juncture. Everybody's given well-intended and I think truthful testimony about what they believe on this thing. And right now, everything is going all right for the mom, but it can crash and burn in a New York second and hurt these kids again. I know that, you know it, and you know it. That's the reason you fight so hard every day. And you don't, and nobody that I know wants to be a drug addict. Nobody wants to be an alcoholic. They don't want that. Everybody said, well, they hadn't been there and fought it if they think it's so easy. If it's so easy, people would walk away from it all the time. We'd snap our fingers and say, well, I made these choices before, but I'm going to quit making it. It's not that easy. So I'm going to suggest that y'all get together here and talk about a reunification plan predicated on the continued progress of the mother. You know what? Let's just do a hopeful, prayerful consideration that she continues to improve. And I want some psychologist or child psychologist or expert to tell me and tell this court what the best way to approach this is, because Lord knows I'm not prepared to make that decision on what I know and what I've experienced. I don't know. And I don't know whether anybody else in this room is. You might have more experience than I do on it. I don't know what the right thing to do. But I'm going to leave things the way they are right now for a month or two and not have these video things until we can get some expert opinion. And I want everybody, I want to do it in a month or a few days. I don't want it to last it too long. The roughest day that I've ever had as a circuit judge, and I still can't hardly talk about it, was, and I'm going to share this with you. I want y'all to think about this. We were either here, I believe it was here. I'm pretty sure it was here. And there were a bunch of young ladies over here in orange suits. And they were all waiting their turn to come up and tell their story about why they should be out of jail and how they were going to get better and what they'd done. Everybody has a story. My favorite phrase, everybody does have a story. Now, we don't ever listen to somebody. And there was one young lady who was sitting there that got what was going on in every case. You could just, as I used to say, my old law professor, she got the joke. You know what I mean? She was understanding what was going on, and she understood what, the gallows humor that was going on and what was going on and everything. And I kept on waiting for her to be called up to see what her story was. And they didn't call her up because she was here on a termination of parental rights. I thought she was here, but she'd been transported from a prison where she was. And so we heard all the testimony. She had 2 or 3 kids placed here, there, and everywhere. And she had this infant that had been placed in a foster home. And I had to make the decision on whether to terminate her parental rights or not. And when it came time to, I couldn't even get the words out. But I had to do it because of her history. Multiple children that she placed and lost and that sort of thing. I had to do it. She said she was doing everything she could, and I'm sure she did. I went back in my chambers. It was awful. But I terminated her rights, and she let a yell out that I'll never forget. It was a primal yell. So I still think I did what was in the best interest of the child, but I might have taken the only thing she had in her life that was going to keep her going in the right direction. But that's not what it was about. What it was going to take to get her where she needed to go. And that's not what it's about with you either. I want you to get better and I want you to do all these things, but it's not about that. And I can't really think that I've ever seen a situation where little children are so adaptable and they can take so much. It's unbelievable how they can come back. I want these little kids to hear that their mom's getting better, and I want their mom to get better. But I don't want to lay them out there to have their hearts broken. And I think until we find out something different, I'm not going to order any additional. I'm not going to really terminate anything. I can delay it right now until we get this additional information. Somebody will be to see you. There's somebody out there to see you, and I want you guys to work to find somebody that's acceptable, Mr. Pennington, that y'all can agree to. And somebody might have to pay some money to do this. I don't know, y'all. I don't have the ability to order that from any pot of money unless the cabinet has somebody. I don't know what they have, but that's what I'm going to suggest. I don't know who it is that's out there. And Mr. Pennington, do you know any experts out there that are like that? You can trust around. So that's going to be my order. I'm going to suspend until we get this looked at briefly. I'm going to suspend any visitations and things like that. Not because I'm unsure. If I was sure, I would completely do away with all possibility of visitations or do it for a long-term period. And I'm not going to do that because I believe that there's hope, that there's grace. So that's what my ruling's going to be. So if you want to draft, y'all want to take something to draft in that is I'm going to suspend visitation for, let's say, a few days and get the parties an opportunity to get somebody to set down a plan to see how we can get back into this thing, how we can assure these children that they don't have a mother that's deserted them, or that they do have a mother that wasn't what she should have been, but she's improving. Because if you don't, I tell you, I see too many of these kids that have problems with relationships in the future. It leaves a scar on them. Yes.
May I ask a question, Your Honor? One, if the cabinet has an expert that could do that for the cabinet to pay that cost, or may I draft a simple order consistent with?
I've never seen you draft a simple order, but you can try.
Yes, sir. And I'll
give it to Miss White, and maybe she can dumb it down a little bit, and then Mr. Pennington can dumb it down a little bit. Maybe even I can understand it, all three of you there. So, and you do what?
I've got a thought. The cabinet, I know Miss Renee knows the case I'm talking about. We had a forensic evaluator. Was he in Lexington in a case recently?
Dr. Feinberg?
No, I've been there myself.
Yeah,
Well, we get a mortgage on the ranch in Texas.
Dr. Evan,
What is the cost of that?
I'm not sure.
Well, y'all, there's no reason for us to discuss.
Dr. Evans is a little bit more reasonable than Feinberg.
You know who that is?
He's in Georgetown.
Okay, well, y'all discuss that away from me, okay?
I was just wondering if the cabinet.
Well, maybe the cabinet will. I don't know, but maybe they won't. So y'all work through the cabinet, work everybody. I'm going to ask you to come back here and report to me on December the 21st to see what the deal is. That's 1 month from now, and I'd like if y'all can reach an agreement. If you can't reach an agreement, then I want you to give me some alternatives to do. And I don't know. I don't know where the kids think she is for Christmas. Where they think she is. They think she's in the hospital. I don't know where anybody tells her where she is, whether she cares about them, whether she's praying for them, whether she's sending them a card. I don't know what we're going to do about Christmas. Y'all just have to think about that. Everybody, it's a hard thing to decide, especially when somebody, has let you down so many times. How many times are you to forgive somebody? 7 times 70, doesn't say something like that? There's numbers like that, but that doesn't mean that you still have children to protect. It's not like you're not forgiving somebody. There's a different layer of responsibility. I hope you understand. It doesn't mean these people here can't forgive you for what they're doing. They're just terribly protective of those children and want to make sure that they're not hurt anymore. And you've hurt them. You have. Terribly. Okay, well, thank y'all for listening to me, we're now adjourned.
May I excuse you?
Everybody may be.
Thank you. We have one more case.
Okay, what's the next case?
My calendar.
Just.
Yeah, if y'all worked out something, Ms. Perigin, if y'all worked out something on your case,
Yes, Judge, the parties have been able to successfully reach an agreement.
okay, so you want to recite it on the record or
It's a lengthy one, I can put it in the settlement agreement.
put it settlement agreement? Okay, thank you. There's no other matter to come before the court. We are adjourned for today.
No, don't be adopted. Come on, no. Oh.